Thank you very much. Thank you.
Good afternoon, Chair. We'll now be hearing from Paul Gasson.
Thank you, Mr. Livingston.
I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Please take a seat, Mr. Gasson. Thank you.
Thank you, Mr. Gasson. Can you give us your full name, please?
Paul Gasson.
Chair, Mr. Gasson has given two statements to the inquiry. These are our references, HOM 03320004, which is the first statement, and HOM 0332-152, which is the second statement. Can I ask for those to be adduced in full?
Indeed, thank you.
Mr. Gasson, what that means is that those statements are part of the evidence of the inquiry, so I don't need to take you through every line in it. So just to start with your role, you were immigration/contract manager at Brook House from May 2014 to January 2018. Is that right?
That's right, yep.
And initially, up till around 2017, there was one Home Office team at Brook House responsible for both monitoring the contract and for immigration issues. Is that right?
That's right, yep.
And were you the manager of that team?
I was, yes.
Yeah. How many people were you managing, roughly?
So there were 7 AO grades,
Yep.
known as contact management managers,
Yeah.
and 2 deputy immigration managers, and then myself.
And you say in your statement, the first statement at paragraph 6, that in early 2017,
Yeah.
Brook House was chosen to run this pilot whereby there was a split in responsibility for contract management and immigration. Is that right?
That's right.
And just clarify something for us, please. In your first statement, you say that the immediate impact on you of the pilot was that you were no longer responsible for the immigration functions. And then in the second statement, you say that you no longer had responsibility for the contract management functions. Which one was it?
What does the second one say?
It said that you no longer had responsibility for contract management functions during the pilot. Is that right?
It's probably meant to say contact
I see.
management.
Okay. So, am I right in thinking then that you continued during the pilot, so during the relevant period in 2017, to be responsible for contract management?
Yes, that's right.
Ian Castle described you as the compliance manager. I'm not sure if that was your job title, but is that where you were?
That's a more recent job title. The compliance team, the DES compliance team, Detention Escorting Services compliance team. That's a relatively new term that came in after the pilot. Before that, it was just contract monitor / immigration.
Okay. So I mean, at a very high level, you were immigration / contract monitor, and during the pilot, you were just contract monitor.
There are grey areas. There
Okay.
are overlaps. It was a pilot, so the structure still hadn't been finalised. Yep.
Yeah. Now, in your first statement, paragraph 8, you set out some of the things from your job description in 2013, and so I just want to check which of those things were still part of your job in 2017 during the pilot. So, monitoring contractual compliance, presumably that's yes?
Yes.
Chairing meetings with G4s, reviewing performance and challenging non-delivery, yes?
Chair meetings up to a point, yes.
Okay. Ensuring detainees were provided with an effective service?
Yes.
Carrying out the Home Office's statutory duties around the centre?
Yes.
And producing reports and briefings?
When required, yes.
Yeah, okay. And as part of your job, you attended Brook House pretty much every day?
Yes, unless there was other work that took me away.
Yeah, I remember you said at one point that there was you were doing work on, I think, one of the bids for the contract extension or something like that.
I
that took you away.
I was quite heavily involved in the procurement exercise from around early 2016 right through to maybe the second quarter of 2017.
Okay, and in your absence, who would be the manager of the on-site?
So when it came to actually marking the bids, I think there was 4 or 5 bids that came in.
Not in the bid. So when you're not at Brook House, so you were in Brook House pretty much every day, but on the days you're not in Brook House, who's the sort of most senior person there?
Oh, one of the deputy immigration managers.
Okay. And did you consider that as an employee of the Home Office who was at Brook House pretty much every day, that you personally had responsibility for setting the tone and culture at Brook House, or did you see that as a G4S thing?
I wouldn't set the tone or the culture, no.
Did you think that you were any part of that?
I think I upheld where I could the expected standards of the DC rules, the DSO, and the contractual obligations that we were working to.
But given that you were interacting with staff and detainees, I think you've said, presumably you would also be part of the culture that they see as well.
Well, if you phrase it like that, I guess so, yeah.
Okay. How often did you visit the wings, roughly? Was it every day?
The actual residential units?
Yeah.
I didn't really visit the residential units that often, no.
Okay. So once a month?
My contract monitoring took in all areas of the centre.
Mm-hmm.
I had my own sort of, not routine, but I had all the areas that I went to, which did include the residential units, was done in a different route. I can explain that at some point if you're interested in it.
Well, but I just want to know roughly how, I mean, you said not that often, but roughly how often would you go to the wings?
About once a week or once every 2 weeks.
Okay. And how often do you reckon you would chat to DCOs and DCMs at Brook House?
In my role as immigration manager, probably not as much as my previous role as deputy immigration manager. It was a bit of a step away from the operational side of things in terms of the actual centre itself. But daily, I'll see staff daily.
In 2017, so
Yes,
you said in
yeah.
your role as immigration manager, but I think by 2017 you're not really immigration manager because that's the pilot.
Yeah, the pilot was there, so contract monitor.
But at that point, how often were you speaking to staff?
So DCMs and above, probably daily.
Okay. And how often do you reckon that you chatted with detainees during that period?
It depends where I was. If I was in the centre, then I would obviously see the detained individuals. My 2 deputy immigration managers would see them on a daily basis.
So you slightly less than that?
It would be less than daily, yes.
Okay. Now, just in terms of the contact that you did have, as you know, because it's been put to you in advance, Ben Saunders suggested that you wouldn't talk to detained people and said that you would shy away from that type of interaction. And Nathan Ward described you as purely functional and clinical about your tasks and not showing any signs of compassion. How do you respond to those descriptions?
I responded to that in my statement,
Yeah.
which I can draw you to, if that's okay.
Yep. I mean, you
I think it's
say
the second statement.
you say at paragraph 65 of your. I think it's paragraph 65.
Is it?
Let's see. Maybe I've got the wrong paragraph. Yep, paragraph 65 and 67. But I mean, if you can help us with, do you accept that you would shy away from interacting with the team
So
people?
what Ben does is, with the context, he compares me to the immigration manager at Tinsley House, who he also describes, who he describes as brash, and will go out in the centre. So I wouldn't shy away from interaction, to answer your question directly, no.
Okay.
When I'm walking around the centre, be it I'll visit all the areas, be it the reception area, the discharge area, the various activities going on. If I saw a detainee in the centre and they wanted to speak to me, of course I would speak to them. I would often take a pen and a pad with me when I walked around the centre, because it was highly likely that someone would want to speak to the Home Office and ask about their case. So if I could take their reference from them, because they all had ID badges, I could say to them, no problems at all, I'll find out for you, I'll go back into the office, and if need be, we'll call you up later today, or we'll get a message down to your wing officer.
And how do you respond to the description of you by Nathan Ward as not showing any signs of compassion?
I mean, I could only assume he was describing, obviously, pre-2014, because I was away from Brook House between, I think it was April 2013 and I came back in May 2014, and I think he left, I think he says close to that date. So the only time I can think that I had interaction with Nathan would have been during the CSU visits. And every CSU visit I went down, Rule 40 or Rule 42, usually Rule 40, Rule 42 wasn't that common. I would have the background information of the person that I was going to see, right quite near the beginning of the contract, myself and the other deputy immigration manager, we put in place a process where every day at 10 a.m, myself, the duty operations manager known as Oscar 1, the duty director came on later on in the period of the contract, but healthcare, we would meet in that unit, we'd go through the individuals, we'd get some information, what were they down there for, etc. If we needed to know that information, what have they been like since.
I'm gonna come on to.
I'm coming to it, and then basically, so my only interaction with Nathan, because he was head of Tinsley House, would have been in CSU, because I don't remember seeing him at Brook House that often.
Okay, so then the question was, do you accept that, or what do you say to the suggestion that you didn't show compassion during those visits?
I don't think that was the case.
Okay.
At all.
I want to come on to ask you some questions about the contract and your role in monitoring the contract. Now, obviously, it's a big, lengthy contract. I'm not going to go through it all in detail, but very broadly, Mr. Gasson, as I think you talk about, Schedule D of the contract set out all of the things which G4S were required to do under the contract, and Schedule G set out the performance measures if there was a failure to comply. Is that right, as you remember?
Absolutely right,
yeah. And in terms of evaluating G4S's performance under the contract, you set out in your statement, your first statement at paragraph 14, some of the ways you would do that. So you say that partly it was through self-declaration from G4S, talking to staff, reviewing raw data, checking the cleanliness of the centre, ensuring there'd been correct authorisation for Rule 40 and Rule 42, reviewing use of force reviews, and dip sampling complaint responses. Now I'm going to come on to some of those individually in a bit.
Okay.
But did you feel overall that through those various means that I've just read out, you as contract manager were able to adequately monitor whether G4S were complying with the contract?
I think with Schedule G, pretty much most of Schedule G.
And what about with Schedule D, with the longer list of things that they were meant to be doing under the contract?
Schedule D was the operational spec. Schedule G was what performance measured, but what performance measures could be brought up against. Not everything in Schedule G. Not everything in Schedule D. So the operational side of the contract was in Schedule G.
Yeah, and so did you see your role, or was your role only to monitor the bits of the contract that could lead to penalty points under Schedule G, or was it to also monitor Schedule D, the things under Schedule D?
Yeah, both, yeah.
Okay.
A bit of both.
And did you feel that overall, through these various means, you were able to actually monitor whether G4S were providing adequate care for the detained people at Brook House?
Care, what do you mean in terms of day-to-day well-being, looking after them, giving them free cooked meals a day, enabling them to have showers? Yeah, the responsibilities of the Home Office the Home Office has contracted out to G4S to look after people who are detained at Brook House. From what I could see, obviously there were areas that they didn't, because their performance measures were applied, and I think that's probably quite apparent in. Not looking at performance measures. I'm asking you whether you felt that in your role you were able to actually monitor whether G4S were providing sufficient care to the people at Brook House. In as much as it was kind of me and me only, then yes. You felt that you were? Yes. Okay. Now, in Ben Saunders' interview with Verita, and I don't need to bring it up on screen at the moment, but just for the record, it's Vera 000226 at page 10, paragraph 112. He describes, through the course of him being there, which I think was from 2013 or 2014 onwards, and he says that through that time they developed a more robust contract assurance model, and he says that initially he found that the Home Office were sloppy and didn't scrutinise the contract at all. Was that ever your experience? What time was that? What period of date was that? Well, from 2014 onwards, he says that during that time they developed a more robust assurance model, but at least at some point he's saying that the Home Office were sloppy and weren't scrutinising the contract at all. Was that your experience? That wasn't my experience, no. If we can bring up on screen, please, INQ 000011.
Mr. Gasson, this is the National Audit Office report. It's dated July 2019. If we can go to page 8, please. At paragraph 19. So this is the National Audit Office's report, and they're talking about Home Office oversight of the contract. And it says at paragraph 19, until 2018, the Home Office did not have the people in place to properly verify or validate G4S's reported level of performance. The on-site monitoring of G4S's contractual compliance was part of one executive officer's role, a junior civil servant, who sat in the detainee casework team and focused mainly on monitoring G4S's level of staffing. This was insufficient to enable the Home Office to properly examine G4S's self-reported performance or challenge G4S on its management of the centre. Were you the junior civil servant that it mentions there?
I'd left by that point.
But it's talking about until 2018.
Oh, I see, sorry. The on-site monitoring of G4's contributors, one executive. So that was part of the contract monitoring that we did. One of my deputy immigration managers, he was very much focused on the staffing from G4S.
Who was, sorry?
One of the deputy immigration managers, and I
Who
think
was
that's Simon, and I think that's who that refers to. So part of the contract monitoring role, we were able to do it. So Simon worked hard, one, to get the raw data from G4S, which was very difficult. Once we'd got the raw data, we were then able to compare it to the stats that G4S were providing us.
Is this about staffing you're talking about?
This is staffing.
I'm going to come on to staffing in a bit,
Mm.
but what this says here is that the setup before 2018 was insufficient to enable the Home Office to properly examine G4S's self-reported performance or challenge G4S and its management in the centre. Do you agree with that conclusion?
I think that our team, the contract monitoring, was insufficient to properly look into every area that G4S were operating within the centre.
And is that a resource issue? You didn't have enough people on the ground?
I would say yes. I mean, because our roles were split, even past the pilot, there were still areas of immigration work that myself and my team would be involved in. And a lot of the time, the priority was towards the immigration side of things.
So, I mean,
helping out caseworkers, progressing the cases through to get people, through detention as quickly as possible, because, there was no sort of, we didn't want to, have people detained longer than necessary.
and that focus on immigration, you felt that meant that you couldn't focus as much as you would have liked on monitoring contractual compliance?
No, not as much as we could, and certainly not as much as I understand now that happens. But I disagree with the statement that was the only on-site monitoring.
Okay, well, I just want to understand, so you're saying essentially that it's a resourcing issue that led to you being able to insufficiently examine performance or challenge G4S. Was it just a resourcing issue, or was it also the structure of the contract as well?
We regularly challenge G4S on their failures.
Only their self-reported failures, though.
Sorry, did you say rarely or really?
Regularly, we had
Mr.
weekly.
Gaston, I wonder, you might need to push your seat forward very slightly just so that you're speaking to the monitor a little more. Thank you.
Sure. No, weekly issues raised, failures, other issues that G4S weren't self-auditing themselves, weren't raising themselves.
So you think you were able to challenge G4S and its management of the centre satisfactorily?
In line with the contract. Satisfactory? It would have helped if there was another 2 or 3 people doing it at the same time, of course.
Okay.
But from my walking around the place, observations, I was raising things that perhaps they weren't aware of, and that would go on the weekly issues.
Okay. I want to come on to the extent to which welfare of detainees was prioritised, because you say in your first statement at paragraph 17, the welfare of every detained person at Brook House was a priority and the responsibility of those who worked at the centre. Do you include yourself in that regard when you say those who worked at the centre?
Yeah, of course.
Yeah. Now, if we can have up on screen, please, VER 000226 at page 11. This is a transcript of an interview that Ben Saunders had with Verita. And paragraph 129, I'm just going to take you to a few bits of this and then get you to comment. Paragraph 129 is asked about the Home Office, and it's suggested to him that the Home Office should and could have noticed all sorts of things they probably didn't. And he says, yes, I think that's absolutely fair. Their primary focus was all about the removal process. Absolutely right. Of course they care about the welfare in at different degrees, but yes, their primary focus was the removal process. First of all, do you agree with that the Home Office's primary focus was the removal process?
From removal centre, yes.
And if we can go to the bottom there of that page, please. Paragraph 145, this is talking about you and saying that you would care more about official visits. And if we can go on to the next page, please. And then at paragraph 147, it's noted that you cared more about visits than you did about education delivery, for example. Yes, ACDTs were important, but not part of your daily concern. And talking about you, it says he was more interested in the delivery of removals. And then if we can go to paragraph 249, which is at page 20, please. While we're doing that, Mr. Gasson, do you accept that you personally cared more about the delivery of removals rather than things like education delivery and ACDTs?
No, of course not. It was the removal centre was there to bring people in safely, look after them, give them purposeful activity, and then discharge them at the correct time. The question of welfare was always there. It runs throughout the expectation and the high standards that the Home Office would hold any supplier. So, yes, there was a focus on removals because it was a removal centre.
You were contract manager,
but not to the detriment of someone's welfare. No.
You were contract manager. Why were you focused on removals?
What do you mean?
What part of your role was to focus on removals?
So in Schedule G, one of the performance measures was getting people to discharge on time, handing over to the overseas escorts, and also there was another one about release as well. So that was quite important.
And was that something which, because I appreciate you saying that you looked at all of these things, but we're looking at is prioritisation, and the suggestion that's being made by Ben Saunders, who was the director of the centre, so very senior, is that you cared more and focused more on the couple of examples you just gave there about removals, whether it's discharge or release, than you did about things like welfare.
I don't know how I got that impression. I don't know where he's drawing that from. I don't think I had a conversation with him ever about ACDTs, not, in comparison to removals. There was lots of people who were on ACDTs in the run-up to a removal for probably obvious reasons, but that didn't mean that the person couldn't be removed appropriately and safely. Okay.
At page 20, paragraph 249 there, Ben Saunders says, frankly, the Home Office didn't really care about the people we looked after. That's a very general kind of comment, and I wouldn't want it quoted that way in the report. There are elements of people in the Home Office who did care very much, but the Home Office entity corporately was mostly concerned about the removal process and the functionality of it. So it's similar to the things that I have read out to you, but do you have any comment to make on that, that corporately the Home Office was mostly concerned about the removal process?
Not to the detriment of someone's welfare, no.
Okay. Do you accept that there was no requirement for G4s to report to you or to the Home Office more broadly on the overall welfare of detainees and their overall quality of life?
I don't think there was a requirement, no.
No. And they didn't do so, did they?
Not on an overall pitch, no. We'd get sort of statistics of how many ACDTs were open, things like that, and then sort of cross-compare to other months to see if there was a trend going up or
But
down.
if you were asked what's the life of somebody at Brook House like, you're not getting any report on that, are you?
No.
No. And do you think that overall, and again, I don't think we need to go through and we're certainly not going to go through each provision of the contract, but do you think that the structure of the contract prioritised security over welfare. So for example, the fact that there were big fines for things like escapes compared to the levels of fines or penalties for things like substantiated complaints. Did you think there was an emphasis on security in the contract?
When you compare the points, I guess so, yeah.
And were you given a steer from above? I know your direct line manager was Ian Castle, is that right?
Not at the material time.
Who was your line manager at that point?
The guy I had before was a guy called Carl, who left, I think, in March, April time.
2017.
Yes. And then there was a gap. There was nobody.
Okay. Were you given a steer from anyone from above, either at the relevant period or before, about what your priority should be? So you've got lots of demands on your time.
Sure.
What's your priority? What
Not
do they
really.
care about?
No. But I was, focused on the contract side of things, on Schedule G, for example, because certain things did crop up more than once.
I suppose the question is, to what end were you focused on that? Was it almost a sort of details-based role where you just felt it was your role to find out whether they'd breached the contract and sort of deal with it, or were you dealing with it to some larger end?
It was twofold really, because obviously the contract was there. It was put in place for the reasons I gave earlier, getting people in, looking after them, making sure that they leave on time. But in the meantime, they were living, that was their residence. So it was important to me that the place, at its very basic level, was clean. So when I went round the units, I went round at different times. So if I went round early in the morning, I'd go maybe once a week, I'd pop in about 7 o'clock, I'd walk round every single unit, I'd walk round the entire centre, just to get a sense of the cleanliness. I'd look in the showers, for example, fairly subjective, but if I looked in the shower and thought I wouldn't take a shower in there, that's not clean, it hasn't been cleaned. If people wake up to that environment, the chances are their behaviour may reflect, in some cases, the environment that they live in. So, and also to wake up and be able to have a shower in a clean area, I don't think is much to ask. In fact, it's a very low threshold, really. If I went round at lunchtime or after lunch or before lunch, and the bins are overflowing, for example, then, people have been out and about all morning, so the bins probably will be overflowing. Is there anyone out cleaning at that point? Is there anyone sort of, making the bins nice for when they come out after lunch? Or before lunch, I should say.
So, I mean, to step back then, one of your priorities was cleanliness and the physical environment.
One was cleanliness. Yeah, if I went down to reception, I'd speak to the people in there. Hi, how are you? Basic courtesy. How long have you been here for? To try and gauge how long someone's been waiting in reception, because there was a couple of criticisms in the past where it was taking a long time for someone to come off the van in the sterile area between the gatehouse and the centre, brought into the reception area, go through the reception process and eventually go to the room, especially if it was at night time. So sometimes DETMU, I'm assuming you know who DETMU are, the population management movement for the detention estates, we sometimes got a call from them to say, Tascor, they were the escorting contractor at the time, to say that they got 3 vans outside the centre, why is it taking so long, for example? Or they would say, Tascor dropped someone off last night at 1 a.m. and they didn't leave until 5 a.m. They weren't able to get that person off the van. So in a reactive contract monitoring stance, I would then go and find out what happened to that person. Why did it take so long? Were there staff in the reception area? I would spend time in the vehicle area. They would have a vehicle log. Every single number plate was logged. Every single person who was on that van was referenced. So then I could go back and I could follow that person retrospectively once I got permission to view the CCTV to see how long that person took. And although it wasn't Schedule G, I couldn't necessarily say to G4s, right, this took longer than 30 minutes to get this person from A to B, A being entrance to reception, B being in their room and able to lay down in their bed. It's still a concern that that person was up half the night or more. Don't know how long he's travelled beforehand. To get him through what's going on, and that was more than one instance. So part of the contract monitoring focus, and it wasn't every day, it wasn't every week that I would check the vehicle log. So I'd either be notified by DETMU, who also had their own contract monitoring team for escorts. So we work quite closely with those. So yeah, and then proactively, sometimes I would go in and I would spend maybe an hour looking through the vehicle log just to see how long vans were taking, and if it seemed that there was 3 or 4 vans piling up, why was that?
So it sounds like movement at reception, the length of time people spent at reception and to get in and out was something that was a concern to you at certain points.
It was a concern to me, because, well, for obvious reasons, the welfare of the people. Just because I was working on contract monitoring didn't mean that I didn't care about the people. It was still, from a Home Office perspective, we still wanted people to be looked after.
Okay. Now, I want to ask you about a particular area in which Schedule G applied. If we can have up on screen, please, HOM 000921. This is Schedule G of the contract, page 5, please. And it sets out here, if you look at C, this is one of the areas of the contract which could lead to penalty points. And it says self-harm resulting in injury. And then it says any known incident of deliberate self-harm resulting in physical injury requiring any form of healthcare intervention and involves any failure to follow laid down procedures for the safety of detainees as set out in Schedule G. Do you remember this part of the contract?
Yes.
And what, to your mind, were the laid down procedures for the safety of detainees as set out in Schedule D? I obviously don't need the exact words, but we've looked through Schedule G and there's nothing, Schedule D, and there's nothing that appears to set out any procedures in this regard.
No, unfortunately, the contract doesn't always. Schedule G doesn't always reflect Schedule D, and that was just the contract that was part of Brook House. It was done obviously before any staff, Home Office staff, worked there from 2009 onwards. However, I think it's 14.1 in Schedule D that talks about safer detention and the lay down procedures. So that would be, and I think I might be quoting this wrong, but I'm sure you've got the contract 14.1 onwards, would be having the ACDT procedures, all staff, all officers trained in ACDT, refreshed every 12 months, to have a self-harm strategy, which I understand G4s did have that strategy, an anti-bullying strategy was also under 14 of Schedule D. So those were the laid out procedures that they had to have in place.
So for example, the inquiry has obviously seen some incidents of self-harm which were recorded during the relevant period. So for example, there's one occasion where there was an alleged failure to remove a ligature in time when DCO and DCM entered the room. Would that, in your mind, qualify as a failure to follow laid down procedures?
I think so. In my mind, reading this now, and to be fair, it was the same back then. So, if someone had self-harmed, for example, and the officers were aware of that self-harming and hadn't opened the appropriate document, chances are it probably would have been ACDT if they self-harmed and not a raised awareness document. Would have been ACDT if they'd self-harmed, hadn't opened an ACDT, hadn't informed the Home Office via a Part C that this person's risks has changed, i.e. increased because he self-harmed.
Any of them would be a failure, wouldn't they? Failure to open an ACDT.
If that person then went on to self-harm again and the ACDT document hadn't been opened, then that would, in my eyes, be a clear failure to follow laid down procedures.
Yeah. What about failure to remove a ligature in time?
If the person, well, again, it's not that straightforward, is it? It's a fairly complex environment. If the person was on a constant supervision and he managed to self-ligature, then I think there probably would be a discussion about how that person managed to self-ligature if he was in a constant supervision.
What about if somebody fell asleep when they were doing constant observations and somebody self-harmed?
Well, if they were on a constant supervision, the person fell asleep and that information came through to the Home Office, then I would imagine we would be looking at that untoward event.
Okay. So, but in terms of what would come to you, I mean, is it correct that it was G4s's responsibility to say to you, we've had an occasion where there's been self-harm requiring healthcare intervention which has involved a failure of procedure? It was a self-reporting mechanism.
Yeah.
And so, but what we know is that during the relevant period, there was around 60 instances of self-harm. For example, in July 2017, there were 14 acts. We know at least three of them required treatment. So that meets the first few bits of this. So known incident of deliberate self-harm resulting in physical injury, requiring any form of healthcare intervention. In those circumstances, are you checking whether there has been a failure to follow laid down procedures in each case, or only if they tell you that there's been a failure to follow laid down procedures?
So in an instance of self-harm, we would probably ask, were they on an ACDT? Were there any sort of plan? The answer might be no, but they are now. We've opened an ACDT in light of this incident. But in terms of when they come through reception, they would have had like a risk assessment done. They would have had a healthcare screening. Those sorts of risks may have highlighted.
Yeah, sorry.
Someone who was at harm.
Just to make sure we're clear about what the question is. So you've got in a month, 14 instances of self-harm, at least 3 of which involved injury.
Yeah, sure.
And each of those, even just the 3 occasions, did G4s present you with those 3 occasions and say these people have self-harmed, resulting in healthcare intervention. Here's our paperwork. Mr. Gasson, you now go and check whether there's been a failure to follow procedures.
No, they didn't know.
Okay. So you had to rely on them identifying their own failure to follow procedures.
I don't think it's as clear as that if you look at Schedule D. I mean, it wasn't a case
Well,
of...
I'm looking at Schedule G at the moment because this is...
Sorry, Schedule D, I meant.
I know, but I'm looking at Schedule G at the moment because, as you'll be aware, Mr. Gasson, what we have is a 5-month period that this inquiry is looking at where there was 0 penalties under this term of the contract.
Yeah.
And so clearly that G4S never reported to you that there had been anything falling within paragraph C here. And what we want to understand is whether you proactively checked that that was correct or whether you relied on them not telling you that there was anything under here.
So I think what you're asking me, and correct me if I'm wrong, because I'm struggling to understand the question. So you're saying if someone's reported to self-harm and a Part C came through to say Mr. X has self-harmed and an ACDT has been opened, would I go back to check to see if there was any other information on that person that may have indicated that he may have self-harmed and an ACDT should have been opened earlier?
Or any failure to follow procedures?
Only that all officers were trained in ACDT, all officers had 12-month refresher training in ACDT, so were able to open an ACDT if they should observe or haven't had any interaction with someone in the centre, they identified perhaps a vulnerability in that person, and rather than jumping straight to an ACDT, they might open what was called a RAS, but a raised awareness. But did I go back, did I ask them... I haven't seen any information that this person was vulnerable before he self-harmed.
That's not what I'm asking you. I'm asking you, in each case of self-harm, where there is healthcare intervention, you're told about that. The Home Officer told about each case of self-harm.
Yes, of course.
Yeah. So in each case, as compliance contract manager, do you check whether there's been a breach of the contract or not? Or do you wait for G4S to tell you whether there's been a breach of the contract?
We would... Of course, yeah, I would check if there was a breach of the contract.
And how did you do that?
For self-harm resulting in injury?
Yeah.
I don't know, to be honest with you. I don't know if we did. I don't remember doing that. But an act of self-harm, I don't think it's worded very well. I think it's a strange... performance measure, because the laid down procedures as set out in Schedule D are clear in that they are ACDT, self-harm strategy, refresher training, anti-bullying structure, which they had. They were the laid down procedures. So unless maybe an officer who was on the wing who had gone over the 12-month ACDT refresher and had interacted with that person and had an open ACDT, then perhaps yes.
But you're giving me an example.
I didn't go back and check.
Okay.
I think is the answer you're probably looking for.
Yeah. Moving on, just very briefly on the contract review meetings, you say in your statement that your role involved chairing weekly, monthly and quarterly meetings, at least at one point. But is it correct that as at 2017, you were only chairing the weekly meetings?
Yes.
And you say in your second statement that those weekly meetings were effective in driving forward improvements to meet contract requirements and remedy some of the outstanding issues, and were useful at keeping focus on areas you wanted to see improvement on. What areas was it that you wanted to see improvement on?
So there was a variety of issues which came up, and I think the document's in here somewhere. So right from the basics, from sort of G4s having a secure email address, which was an issue on there for a long time because it meant that we struggled to email them stuff in confidence. And then the more contract monitoring things was things like IT issues. So allowing people to be able to use IT, the rooms, the regime. Having an art teacher, there was a period of time when there was no art teacher, and that was a standalone role. And when I went around the centre and spoke to Seb, who was the English teacher, which is a classroom opposite the arts and craft teacher, he was very enthusiastic, and it was a shame that the arts and craft classroom wasn't open for a period of time. But G4s got around that by putting a DCO in there, so for a period of time it was making sure that arts and craft centre was open. Obviously the cleanliness issues, which I raised.
So it's just sort of stuff you were looking at.
Bringing people up to see immigration officials within 30 minutes. Making sure that on reception that people were being fingerprinted. So if the IABS machine, which is in reception, which I think is the immigration and asylum biometric system, which is essentially when someone comes in, they take the fingerprints. So as part of the reception process, if people were coming in from, say, the prison estate and it was the first time into the IRC estate, the expectation would be that their fingerprints would be taken on reception. We'd get the reception paperwork, it'd come up. If there was fingerprints missing, we would chase those fingerprints. So that would sometimes go on there.
So
passport quality photos.
Mr. Gasson, sorry, we're limited in time, so I need to interrupt you. But so what you're saying is that those are the types of things that you would raise at the weekly meetings
amongst
and drive
others,
forward. Yeah.
yes.
Okay. Now, moving on to staffing levels. In your first statement, you say that you'd question the level of staffing if they fell below the minimum, and ask what contingency plans were in place or plans in motion for things like the welfare office or ACDT reviews and constant watches. Is that about whether staffing was below the minimum over a 24-hour period, or was it over a longer period you'd be looking at?
Both,
Okay.
I think.
Now, if we can bring up on screen, please, CGS 000524. Now, this is a table setting out some of the penalty points, or it's some of the points under the contract. You'll see row 16 there deals with staffing levels. And what you'll see looking across is that it was staffing levels were 100% in April and May 2017, and then go down below the minimum levels thereafter, so 90%, 81%, 87.1, and so forth. To the best of your recollection, this drop-off in staffing levels meeting the minimum requirements, this coincided with Tinsley House reopening. Do you remember that?
Yes, yeah.
Yeah, and that
'Cause there was
happened in-
Tinsley staff, wasn't there, that came across too.
So Tinsley had been closed for refurbishment, and Tinsley staff had come over.
Yeah.
And then in around May 2017, Tinsley House reopened, and so staff went back to Tinsley House.
Yeah.
And this was also around the time of the introduction of 60 additional beds at Brook House. Do you remember that?
I do, yes.
Yeah. And so both of those things happening around the same time, as you can see, made staffing levels go below the minimum consistently from June 2017 until November 2017 at least.
Yeah, sure.
Were you aware of this at the time as a pattern?
As a pattern,
Yeah.
looking at it, I've never looked at it like this, in terms of, you can see the dip and then it sort of gradually goes up again. But the staffing figures, we were aware of the staffing figures because we counted them, and we made sure that they matched what G4s were telling us.
Now, if we can get up on screen, please, VER 000256. This is your Verita interview, and if we can turn to page 9, please. You say paragraphs 111 at the bottom. We're talking about the Tinsley House refurbishment. You're asked at 112 that since then staffing has apparently been pretty tight. Is that fair? And you say yes. And then if we go to page 10, please. Paragraph 117. You're asked about the number of DCOs and DCMs on the wing. And you say, anecdotally, staff say, one's been put on for escort, one's in the courtyard, and that leaves me. The officer is talking on the wing with detainees answering questions. That's anecdotal. I don't physically have the evidence to say it went down to one between these hours. So what you're saying here, correct me if I'm wrong, is that you'd heard people saying that there had on occasions been just one DCO or DCM left on the wing. Is that right?
On occasion, yeah.
Yeah.
That would have been probably raised with G4s in the weekly meetings. I would have said that, I understand sometimes the wings go down to one.
Was it acceptable for G4S to have one member of staff on a wing?
Was it acceptable for G4s?
Well, no, was it acceptable for you?
Oh, for me to know that there was one on there? No, but I reported the figures. I didn't necessarily have those conversations with G4S about for example, the unacceptability of not having the correct number of DCOs on a wing if there was a correct number.
So, in your second statement, you say that the Home Office were aware of staffing levels, but there was an understanding of the difficulties in recruiting and the increase in bed capacity. And you say that you don't recall the specifics of any impact on staff or detainees as a result of low staffing levels. Now, we've heard over the past couple of weeks evidence from a number of former DCOs and DCMs,
Sure.
many of whom have said that staffing levels were too low, that it led to detainees and staff feeling unsafe, that it led to very poor staff morale. One described staff morale as an abyss because of it, and some of those staff said that those staffing levels affected the care of detained people. Now, is it your evidence that you were unaware of these issues at the time?
I was unaware of what you've just said, yes. I mean, that's becoming more apparent now. That was quite well, for want of a better word, hidden from me. We were aware that the minimum staffing figures were below the expectation. And bearing in mind they are just minimum staffing figures. That was the minimum staffing figure set in the contract to run the centre. There was nothing to say that G4S could have more staff than the minimum staff from.
I mean, doesn't it follow
requirements.
logically, Mr. Gasson, that if you've got a minimum level of staffing in a contract to care for detained people, that if you fall below that, that's going to affect the care of those detained people?
It probably would.
And who was responsible from the Home Office for saying that's not good enough, G4S? You need to have enough staff.
Well, from my level, it would be the performance measures. So when
Who
it
is
did
responsible
for?
saying to the G4S that this is not good enough, you need more staff?
Oh well, I mean, I don't like to blame it, put anyone's feet, but I'd imagine the delivery service manager had meetings and had talks with G4S about their response and their recruitment methods and what their any sort of plans they had to try and increase their staffing. I mean,
So sorry to interrupt you again,
That's
but
right.
so are you saying that the responsibility was above you because your responsibility was just to report the staffing levels?
to a degree, yes, of course, I did report the staffing figures, and it was sort of reported monthly. In fact, we worked on the staffing figures every day. But the assurances, from my memory, from my recollection of monthly contract review meetings, from quarterly contract review meetings chaired by the service delivery manager and commercial, respectively, was that staffing was talked about, and G4S did speak about a recruitment drive to try and bring people in. Did the question around the welfare of people detained affected by that? I don't believe it. I don't remember a conversation where that came up.
So do you think you and your colleagues just missed it?
I don't know if it was missed as such.
Well, we've heard evidence from a number of. I mean, you've seen some of it. I mean, we've heard evidence from a number of staff members about this being a really central theme of their day-to-day life at Brook House, was that staffing was always too low, and it meant that they'd be looking after the wing by themselves. It meant they couldn't open the courtyard in time. It meant there was no one to do activities with the detained people. You were monitoring the contract, which set a minimum level of staffing. So wasn't it your job?
It set a minimum level of staffing.
Yeah.
It didn't set the minimum level of staffing on the wing. That's not in the contract.
Okay, well, we know that it was below the minimum levels of staffing. You knew at the time that they were below the minimum levels of staffing. So wasn't it your job to take action, or was it just to charge penalty points?
It was, obviously it was to put the performance measures across, so what the staffing figures showed, and there was obviously a table with certain percentages, and where it hit certain levels, a level of performance points would then be awarded. And then it was down to G4s. G4s had the responsibility in this contract to make sure that they were hitting the minimum staffing level.
Okay, now we know that in your, we don't need to go to the, actually it's right on this page, so while we're here, at line 118 to 119, you're asked whether G4s would incur any fines over staffing. You say yes, but they weren't massive. And without going to each of the documents, our analysis of the penalties that were levied at G4s during the relevant period was that it was around £2,250 over 3 months. So from June, July, August 2017, it was £2,250. Now, stepping back from it, Mr. Gasson, you've heard some of the evidence from G4s staff about how terrible the situation was with staffing, and I'm telling you that the penalties were around £2,250. What do you make of that, stepping back from it? Was that enough?
Oh, so you mean? Well, obviously, as I say in my statement, there was a balance to a point where it would be obviously less expensive for G4s not to recruit, although they were actively recruiting, because I know that, I think in my first or second statement, I used to go along to the new DCO, part of the ITC, and do a presentation. So they were pretty much back-to-back recruiting, so that was going on. The problem was staff attrition. In answer to your question about, what was it? I forget, I'm so sorry.
Well, we've heard evidence from lots of staff members about how awful staffing levels were, and about the impact that this had on staff, on detainees.
Yeah.
And the fines that the Home Office levied, or the penalties that the Home Office levied, were £2,250.
Yeah.
So what I'm suggesting to you is, does that either mean that the staffing levels in the contract that were specified were too low already, or does it mean that the penalties were too low, or does it mean neither of those things?
I think I could only work with the framework of the contract. That was my job.
I'm asking your opinion.
That's what I did. The minimum staffing levels were probably set at a time when perhaps the focus wasn't so much on welfare as it is now. I think on reflection, if it was done again, and it has been done again recently, you can see the increase in staffing. That's evident in the number of staff, and I think Steve Lawton touched on it in his time here. It's like a different centre now than it was back then. So that wasn't the only area that G4s could be performance measured. By that, sorry, that was the first step. In Schedule G, there's also an area where there could be a notice of improvement.
Yeah, that never happened during the relevant period.
Not as far as I was. That would have been a commercial-led thing. Okay. That wouldn't have been for a higher executive officer working in an IRC who was monitoring the contract. That wouldn't have been for me to raise, or certainly to get the go-ahead to do that. I could have raised it as a suggestion. Of course I could.
But you didn't.
I didn't at that time, no. Yeah. And then there's another step as well as part of the contract.
Now, one of the things you do say, talking about the levels of senior management, you say in your statement that your opinion was that the G4s senior management team was under-resourced for certain areas, but that wasn't an opinion you shared formally. Why didn't you share that opinion formally?
I think when you say formally, is it in writing anywhere?
You say formally.
Oh, okay.
You've said
probably in that case, then is that an interview with Kate Lampard?
No, this is in your witness statement to this inquiry, paragraph 29, first statement.
So by that then, I'm sure I meant that I didn't put it in writing, but I may have raised it with maybe Ben or Steve.
I mean, you're saying you may have done. Did you?
I don't remember it, but
Okay.
if I put it in a statement, then I mean I don't think I did formally know, but I thought the SMT was quite small for the area that they had to cover.
Okay.
I'm not sure if that was my position to say that, to be honest.
Well, you were the contract monitor, so you were monitoring the extent to which G4s met the terms of the contract. So if that was something, and you were the most senior person on the ground at Brook House from a Home Office perspective, so if not you, then who?
Yeah, but the number of senior management, the number in the senior management team wasn't part of the contract. They didn't say you had to have X amount of SMT. These areas had to be covered. G4S decided their own senior management team, and they decided how they thought best to deliver the service in line with all the statutory instruments, DSOs, and the contract. And if their decision to have, I don't know how many SMT they had, sometimes it felt quite short.
Okay,
Especially the residential manager. He had a very big area to cover.
that's Jules Williams, yeah.
Yeah, he was. I thought he was fairly effective, but he had such a big area to cover, a 24-hour a day, 7-day a week centre for one person to cover that. I thought that was quite a stretch for any person.
Okay, now I want to move on to the issue of Rule 35s, Mr. Gasson.
Yep.
Your role in Rule 35s, you say in your statement, was that you ensured that the Rule 35 process was completed for every case from a Home Office perspective, yes? Is that right?
Say that again, sorry.
Your role in terms of Rule 35s
Yeah.
was ensuring that the Home Office side of it was completed in every
Yes,
case,
yeah,
yes?
yeah. The Home Office side, within the IRC
Yeah.
responsibilities, yes.
So you say that this involved passing completed Rule 35s from healthcare immediately to the caseworker,
Yep.
updating CID, adding the details to a whiteboard in the immigration office,
Yep.
and a local Rule 35 spreadsheet,
Yep,
and ensuring that each case was dealt with promptly, yeah?
that's right, yep.
How would you be notified in the first place that a Rule 35 had been completed from healthcare?
It used to come through as a fax,
Okay.
and then it later came through as an email transmission.
And would you, so that's it coming into you, you then pass it on to the caseworker makes the decision about whether the detainee should be released in response to it.
They would carry out detention review, yes.
Would you review the substance of the responses?
Yeah, so at the time, the process was the immigration team, so the contact management team would receive that notification from healthcare, they would pass it to the casework and then do all the bits that you just said, update the spreadsheet, update the whiteboard, and then if a response hadn't been received within 48 hours, they would chase the caseworker or escalate it to their manager to make sure that, you know, a response came through to us. And then, depending on the response, one of the parts of the process was that the HEO, so myself, would have a look at the response to see if it had considered what was in the Rule 35 report.
So you would review the adequacy of the response from the
As far as I
caseworker?
was able, yeah. I mean, if the Rule 35 report, you know, said X, Y, Z, and the caseworker had only considered X and Y, I might say you bring the caseworker up. They even need to resubmit it. Or why was Z missed off, for example? Is there a reason for that?
Were you aware in 2016 of the HMIP report about Brook House, which expressed the view that some of the Home Office's Rule 35 responses were poor?
No.
Was that ever passed to you?
I didn't see that part of the HMIP report. No.
Okay. So you wouldn't have taken any action in response to that? Would that have been the caseworker team who would be responsible for considering that?
Yeah, I mean, yeah, they would have written the Rule 35 response. I'm I have to check, but I'm sure it was quality check their end as well before it then came through for service, and it was there really as more of a safeguard. So, I mean, I wasn't there every day. You know, I didn't work there 7 days a week, so there would have been responses that came through, and sometimes I worked weekends, which meant that I had a day off in lieu either side of that weekend, so there would have been times. But it should have been checked a bit like the detention reviews. You know, sometimes that they would be sent back by by the immigration staff at the IRC simply because they would be going down and they would be serving that document on the person in front of them. If the caseworker, and it didn't happen often, but when it did, you know, if it did happen, if all the caseworker had done was literally just change the date and sign at the bottom, but there'd be no progress on the case to reflect what actually happened in the last 28 or 30 days,
Okay.
then we would make sure that that would go back because we wanted a proper update for the person
What
receiving
I
it.
want to understand is if there is criticism of a response to Rule 35 report, Do you bear any responsibility for that, or is that responsibility that's held by the caseworker team?
The responsibility sits with the caseworker team. However, I do take some responsibility, yes, because if I'd viewed a Rule 35 response and HMIP had viewed a Rule 35 response and they had thought it was inadequate, then I would need to know that. I would need to perhaps know where those failings were, so that later on I could make sure that I covered those points.
Okay. Now, we've heard from two GPs who worked at Brookhouse. They still work at Brookhouse. I don't know if you saw their evidence, Dr. Israeli and Dr. Chowdhury. And they gave evidence that they wouldn't just use Rule 35 to notify the Home Office about adults at risk.
Okay.
They would also use Part C forms if they thought that somebody was at risk.
Yeah.
What process would you follow the same process upon receipt of a Part C as you would a Rule 35, or was there a different process?
So the Rule 35 prompted a detention review from the caseworker. A Part C was a change in that person's risk. So if it came from healthcare or GP, depending on what the information said on the Part C, all Part Cs would go to the caseworker, and they should react to the information on the Part C.
But it wouldn't prompt, are you saying, as far as you're aware, it wouldn't prompt a detention review in the same way?
Not in every single case, no.
Okay.
Depends on the information in the Part C.
We heard from those healthcare witnesses, and we also heard from the healthcare manager, Sandra Calver, and some other witnesses, that during the relevant period, were you aware of the 3 different types of Rule 35 reports that there could be?
There were 1, 2, and 3 of the limbs of the rules. I think.
I'm not going to quiz you on it,
Good.
but were you aware that during the relevant period there were no Rule 35-2 reports and only a small number of Rule 35-1 reports? Is that something you would have had any oversight of?
No, I wasn't aware of that. Most of them were Rule 35-3,
Three,
which
indeed.
was torture or special illness, I think.
Indeed. So what I want to understand is, from the Home Office's perspective,
Yep.
I know that you have a limited role in this, but you have some role in it.
Yeah.
Who is responsible within the Home Office for thinking, one minute, we've received no Rule 35-1 reports, or no Rule 35-2 reports in 5 months. What's going on here? Whose role was that? Whose job was that?
I don't know. I don't know if there is one. There's a Rule 35 team now
Okay.
that was set up, I think, either following, it may have been Stephen Shaw's report, I'm not 100% sure, part of the detention gatekeeping team, I think, but I'm not really kind of in a position to give sort of information on that, because I don't know the full ins and outs, so it wouldn't be fair. But
Okay.
I am aware that there is a Rule 35 team now specifically dedicated.
Just a couple of other things on this related to this issue. Karen Churcher, who was a nurse at Brook House, told us last week that in her opinion a lot of mental health was not taken seriously by the Home Office, she said, I think.
Right.
Is that something that you felt was the case within the Home Office?
No. How does she mean that? How do you mean? How would the Home Office not take it seriously? People on site or the caseworkers? Or?
I'm just putting to you what
Oh,
she said.
okay.
But do you disagree with that?
I disagree with that. Yeah, I don't know what she means by
I mean,
that.
do you think that you took the mental health, personally, that you took the mental health of detainees seriously?
Of course, yeah. I don't know in what context we wouldn't take it seriously.
Okay. Karen Churcher also told us about people from the Home Office telling people who were suspected to have suicidal ideation or who were self-harming that they would be better off in detention rather than being released from detention. Did you ever tell a detainee that?
No.
Okay. Did you ever hear of it, someone from the Home Office telling a detainee that?
No.
I want to come on to the issue of complaints now. Mr. Gasson, you set out in your first statement the role of your team in the complaint process, which was primarily, I think, to ensure that there were sufficient complaint forms and then to collect the complaints and pass them on.
That's
yes?
right, yeah.
But part of your role also included dip sampling complaint responses, is that right?
That's right, yeah.
And is that just the responses where G4s investigate themselves, or is that dip sampling responses including where it goes to the PSU as well?
Not the PSU wasn't included as part of the. I think it's very low. It was like 5%. So sometimes they have to do more than 5% because there might only be sort of 10 responses that month. So almost pointless doing one response.
Okay.
But no, it didn't include the PSU responses.
Did anyone from the Home Office review each complaint that G4s responded to, or was it just the depth sampling? Was that the only review from the Home Office's perspective?
I don't know actually what was in play. I don't know if maybe what is now known as the corporate oversight and operational team, if they did any analysis back then on the themes or types of complaints, or if any sort of reports was generated.
Okay, well, I
don't
don't
know.
want you to speculate on that,
No.
but from your perspective and your team, was anyone stepping back and considering patterns of complaints? So, for example, we heard a couple of weeks ago that there were 13 complaints against a DCO who became a DCM over around a 2-year period. Was that something that you would have been aware of? Would you have stepped back and looked at a pattern?
If
like
I'd
that?
seen it, it would have raised suspicions and it would have raised concerns, and I would have wondered why the same officer's name was cropping up in complaints.
But I mean, I suppose the crucial thing there, which you've just said, is if I'd have seen it. And what I'm
Yes.
asking is, were you or any of your colleagues taking steps
see,
to
okay.
see that thing?
No,
type of
is
thing?
the answer. The process, the way the process worked, meant that one of 2, sometimes 3 people could have scanned the complaint and sent it through to the central complaints team. So I think that question might be better off asked centrally, if you know what I mean. They might see
Okay.
a theme.
Now, given the role that you've just set out for you and your team in the complaints process, I want to ask you about a specific complaint. If we can bring up it on screen, at CGS 001616. At page 3. Now, I'm not going to read through this, Mr. Gasson, but this is, to summarise, a complaint from someone who the inquiry knows as D2953.
Mm-hmm.
It's a complaint that was made on the 23rd of June 2017, and he complains about being beaten 3 times by a member of staff, and also complains about not being given his medicines. Now, without going through each page, I can tell you that we know from the documents that he received a response in relation to the medicines complaint, but didn't receive any response in relation to the allegation of being beaten 3 times until it wasn't investigated until 3 months later by G4s, and it wasn't passed into the Home Office until a month after that, so until October 2017. Now, ultimately, when this was investigated, the PSU substantiated this complaint. So they found that a staff member had punched this person 3 times in June 2017, but that staff member remained in employment until September or October because this wasn't investigated. And we know from the PSU investigator that she never received a copy of this complaint even when she was carrying out her investigation.
Mm-hmm.
Who's responsible for that failure to pass on this complaint or to investigate this complaint?
So if that complaint was put in the yellow box on one of the residential units and it was collected by a Home Office member of staff, one of the deputy immigration managers should have read that complaint to know that one part of it would have gone to healthcare and part of it should have been sent to the DES complaints team, and then that should have been, so they would have probably scanned it and sent it twice, one to healthcare, as I say, one to NHS and one to
But they didn't, obviously.
apparently not.
And so who's responsible for that? Is it the individual? Is it you? Is it someone more senior?
I would imagine it was probably the individual. I mean, I don't know what part of it they read. Maybe they read the first line and saw doctor, or medical staff. Maybe they didn't read it all the way through. If I'd known about it, I obviously would have picked them up and maybe.
Yes, but you understand that we don't know that either, because we can't go back in time and see who picked up this complaint. All we know is this is a complaint that wasn't passed on and that this member of staff stayed in post for several months.
Sure.
And so are you saying that it would just be a mistake on behalf of the deputy immigration manager? Or whose mistake is it? Whose fault is it?
They're the ones who would have read the complaint initially. If it didn't get passed to the right place, then ultimately that was part of their role, wasn't it? To pass it to the correct place. If they'd missed some information, which to be fair is quite badly. It's not, you know, it's not that the writing is quite scrawly. However, I can clearly see I was beaten. That would have drawn my attention in if I was looking when I used to do that role. I would read the complaints to make sure it was going to the right place. If that definitely came into the immigration office, then it was an oversight by the member of staff. I'm just pleased that, you know, it was rectified and it did come back to us, and PSU had the opportunity to look into it.
Moving on, I want to briefly ask you about some involvement you had in a complaint ultimately raised by David Waldock. And I'm not going to go into this in detail with you because it's going to be discussed later this afternoon. But this arose when a colleague of yours, Vanessa Smith, emailed you saying that DCO Waldock had been really rude to a member of staff, a G4S member of staff, and you passed that on to G4S. Do you remember this?
Yes, yeah. I remember because I've seen the email, yes.
Yeah. And then, if we have up on screen just briefly, please, CGS 00733634. And this is a chronology of matters, and we can see that, so it has your name at the top, you were emailed, then you emailed Kaz Dance Jones on the 25th of January, and then further down, 1st of February, you sent an email to Ben Saunders saying there was still an issue and providing a list of concerns. And then on the 3rd of February, it was confirmed to you that DCO Waldock had been moved from visits and was being performance managed. Okay. Now, ultimately, the outcome of this was that DCO Waldock raised a grievance, and that grievance found that he had been that matter had been poorly handled by G4S, and that one of the problems was that when the complaint had been received from the Home Office, from you passing on Vanessa Smith's complaint, that they'd taken the easy option to move him rather than investigate it themselves. Okay. Were you aware of that as an issue?
No.
Did you see yourself as just a sort of postbox in this regard?
I think in this particular one, yes, there was the interview corridor area had become a focus for us in getting people up on time so the Home Office could carry out the work, progress cases, etc. on behalf of the caseworkers. And Kaz Dance Jones was put in by Steve Skitt to oversee that area, so she was my go-to, my Spock as it were, for that area, single point of contact for that area, to raise any issues. This issue came to me from a member of, at that moment in time, maybe part of the pilot team Vanessa was on. She emailed me her concerns, and I passed it to Kaz to ask for some reassurance in this area around the staffing, because there have been problems with staffing previously.
Did you consider this was an example of the Home Office pushing G4S to take one side or the other?
No, it was up to them to investigate. They would have had their own staffing procedures. Okay.
More broadly, in relation to complaints, as you'll have been aware as compliance manager, one of the performance measures in the contract was about substantiated complaints.
Yep.
Did you think at the time that created a perverse incentive for G4S to not find complaints substantiated?
Quite possibly.
Now, we've seen examples of PSU reports that were carried out following things that were reported during the relevant period, where findings have been made that detainees have been assaulted, officers found to raise their voice to detainees, officers sacked for swearing at detainees. Would you have expected each of these type of things to lead to penalties under the contract for being substantiated complaints?
If it was put in as a complaint, then yes.
Moving on to your knowledge and oversight of use of force.
Just on that, if I may, on the issues log in May 17, I think it was, there is an instance of that. It's filed under other complaint where someone who engaged in paid activity, I think they may be cleaned, I'm not sure. The complaint was twofold. One was about not being let out of his room to be able to do his paid activity, and therefore I'm assuming not getting his £1 an hour or just the activity, and one was being mocked by members of G4S staff, so DCOs.
Yeah.
And on that, on the mitigation tables, it went on to be called rather than the issues log. The first part wasn't substantiated, but the second part, G4s did an internal investigation into that, and they found out that that complaint was actually true. They found out that that person was mocked by an officer or officers. I can't remember exactly.
Yeah.
Excuse me. And that carried a performance measure of 100 points. So although I was asked to mitigate it, I think, at that point, because they'd done an internal investigation and that person had probably gone down the disciplinary route, whatever that was, I'm assuming dismissed, because his certification would have been suspended anyway, given the behaviour he engaged in. They were still pointed. So if it came through the official complaints channel, i.e. a DCF 9 was submitted like this individual did, and it was found to be substantiated, then yes, regardless of if that person was sort of dismissed or not. But in that case, obviously the expectation would be that he would be, or they would be, or she would be.
Okay. Moving on to use of force, if we can have up on screen, please, HOM 000916 at page 126, please. So this is part of Schedule D of the contract.
Yep.
So this is the schedule relating to use of force, and just at that box that we can see in the top left of the screen, the requirement is said, the contractor shall ensure that force is used only when necessary to keep a detainee in custody, to prevent self-harm, violence, the destruction of property, and to prevent detainees from resisting their own removal or physically interfering with the lawful removal of another detainee. No more force than necessary will be applied. So that sets out a list of the circumstances in which force can be used on a detainee, yes?
Yes.
In fact, it says only, so it's an exhaustive list. Would you agree? Force is used only when necessary to.
Yes, yeah.
Now, we've seen a number of use of force reports from the relevant period where the reason for the force used, as written on the form, is to maintain good order and discipline. That's the reason given for the use of force.
Okay.
Now, looking at that list there, do you think that maintaining good order and discipline falls within any of those reasons for the use of force?
On its own, probably not. There should be probably some elaboration on that sentence to say exactly what, why use of force was used.
Okay. And your role as compliance manager was, I think you told us earlier, not just to look at Schedule G, which is the bit that attracted performance points, but also to look at the extent to which Schedule D was met. And this Schedule D sets out a load more things in relation to use of force. It says all force must be reasonable, only approved techniques may be used, planned use of force must be recorded and retained on video for 3 months, and various other things. Who from the Home Office, if anyone, was checking that all of those things were done each time force was used? Was there anyone?
I don't know if it was each time force was used, but there was a use of force monitor that sat within detention and escorting services as part of the security team, and there was a standalone role that was called use of force.
Whose job was that?
Monitor. The name?
Yeah.
Ooh. I don't know, I'm sorry.
Okay. But it wasn't your job, that was someone else's job.
For the use of force monitor, yeah, so they would have probably, I'm assuming, done the use of force, done the control and restraint course, be knowledgeable in the different techniques, and then if they had concerns, maybe pass it to an instructor to have a look at as well. I don't know their procedures.
Now, would you accept that, at least during the relevant period, I believe it's changed now, there were no performance measures, no penalty consequences for inappropriate use of force?
I don't remember ever seeing it in Schedule G.
Yeah. So we can see, and it's in the National Audit Office report, we don't need to bring it up, but as far as you were aware, it was obviously your job to
Yeah.
monitor this stuff. There wasn't a certain number of points that would be applied to an inappropriate use of force, was there?
No.
No. And and presumably the consequence of that is that the various things that this inquiry has seen, which might be found to be an inappropriate use of force, don't attract any penalty points.
No, they don't. No, not under the contract back then.
And in fact, the only way that they would be penalty pointed is if there was a complaint about that was substantiated, isn't it?
That or a member of staff raising it, which has happened before in my experience.
But what would be the penalty point then? If a
Oh,
member
the
of
penalty
staff-
points? No, there wouldn't be a performance measure as such.
Yeah.
No, I mean
There's no-
G4s might lose an experienced member of staff, but they wouldn't be awarded a performance point as such because inappropriate use of force was used by a member of staff.
And given the seriousness of using force on a detained individual,
Yeah.
does that strike you as an important gap in the contract?
I think so. I think, looking at it, how use of force, and the nature of the use of force, the first time you see use of force, and I've witnessed a few in my role, it's quite an alarming experience the first time you see it. But I agree that perhaps, but I think that maybe would be, I don't know if it's in the new contract, but from my point of view, from a contract monitor point of view, I wouldn't necessarily know. Obviously, if it was obvious, someone was clearly assaulting someone, and that was part of the use of force report, then yeah, but looking at use of force, I wouldn't know if certain techniques being used were incorrect or possibly risk a risk to the person.
And you say in your statement that there were some occasions when you were personally informed about a use of force being used and your name would be on the form as having been informed about that.
Yep.
And you say at paragraph 120 of your second statement that when you were informed about a use of force, you would read through the reports to ensure nothing of concern and you would ask about the background. Is that right?
So yeah, so that kind of, what I meant by that was sometimes use of force. So if I was on call for that week, I was a duty on call for Brook House, I'd get a call because it was outside of office hours, for example, just to say, Paul, just to let you know, use of force has been used on Mr. for this reason, and then I'd ask a bit more information about it. If it wasn't obvious why use of force was used on that person, I'd ask a bit more information.
Did you ever watch the footage of a use of force in those scenarios?
I did. Did I watch? I watched some use of force, but that was part of the use of force meeting. No, again, I could watch use of force and think it was okay. I wouldn't be able to pick out the technicalities.
Yeah, because presumably, as you said, you wouldn't be able to actually assess whether use of force was done properly because you weren't trained in it and
Yes.
you wouldn't have known. Is that right?
That's right. Yeah.
Okay. But you do say in your statement that one of the ways that you'd evaluate G4s's performance under the contract is reviewing use of force reviews.
Yeah.
Is that right? Now, we've heard evidence from Stephen Webb, who used to carry out some of those reviews,
Okay.
or who did carry all of them out during the relevant period, the ones that were carried out. He told us that they were all done by him in his time off as a tick box exercise, and done 2 to 3 months after the incident had actually happened.
Okay.
Is that something you were aware of?
No. So my understanding of the use of force is that it would go through certain managers to also read it. So by the time it got to the Home Office, and sometimes that was why there was a delay on use of force reports.
I'm talking about the use of force reviews. You say that you
Oh.
would review the use of force reviews.
I would read the use of force reports.
Yeah, the reviews is
No.
what you say.
Oh, do I?
Yeah.
In that case, then I probably meant report.
Okay.
So the use of force reports would come into our immigration office, and I would read through them. Some of my colleagues, or 2 of my colleagues, would read through them as well, just to see if anything did jump out at us that perhaps we should be raising, anything of concern.
But I mean, in reality, Mr. Gasson, that's not really any sort of oversight at all, is it? Because you don't know what you're looking for, and there's no one from the Home Office who does know what they're looking for who's actually checking this, is there?
So the use of force monitor I mentioned earlier,
Yeah.
they could come in and look at any use of force that they wanted as part of the contract. I think the 3rd column, how G4S would audit, things like that. They should have their senior management team or member of the senior management team or CNO instructor, they should be reviewing it. I mean, what you've just said about that CNO instructor reviewing them as a tick box exercise, well, it's you know, it's alarming, isn't it? That's quite shocking to hear that now. I didn't know that at the time.
Okay. Now,
But that responsibility surely sits, I would say, with G4S. But having now known that, if I'd known that at the time, I obviously would have picked it up with G4S and perhaps brought that to their attention and looked at ways to improve that way of doing things.
you say in your statement that there were monthly use of force meetings from at least 2015, which were chaired by G4S Head of Security, which a member of the Home Office would attend. But the Verita report into Brook House found that those hadn't been taking place at all since 2016. Does that accord with your recollection?
They were quite inconsistent. So what should have happened was there was a monthly security meeting, and then following on from that monthly security meeting, the use of force meeting should have continued on.
And why wasn't someone from the Home Office raising concerns about those not happening?
I don't know if they did or I don't know if they didn't. I don't
Well,
know.
Did you ever raise concerns about those not happening?
I don't remember raising them as
Because it's part of the contract that they have use of force meetings. You're a compliance manager.
Not necessarily for the Home Office to attend, so they would be reviewing it internally. They should be reviewing their own staff use of force.
But Mr. Gosson, you're a compliance manager. It's your job to check that the
Contract
G4S
monitor, yeah.
contract manager.
Monitor.
It's your monitor. It's your job to check that that G4S are complying with the contract. Part of the contract says that there must be recorded, retained on video. The IMB must be informed. Use of force reports must be completed.
Yep.
But were you checking that?
Use
for
of force
G4S?
reports were always completed, and if they weren't, we would chase those use of force reports because we'd be aware any reported use of force we would be aware of, and then the use of force reports. The expectation was that within 24 hours, those reports should be with immigration on site. Sometimes we used to come in the morning, and the use of force reports used to be posted underneath the office door because our office was locked. And we would chase those. So that part of the contract, yes, it was. We would chase those use of force reports.
Okay. I want to move on to Rule 40. As part of your role, you would join staff on a Rule 40 or Rule 42 visit a couple of times a month, yes?
Maybe more than that. As immigration, as contract monitor, yes. Yeah.
Okay. Now, you were asked about some occasions when you were notified that a detained person was placed on Rule 40, and you were also asked about some occasions when you authorised that a detainee be put on Rule 40.
Yeah.
You say at paragraph 122 of your statement that for the cases where you weren't authorising Rule 40, removal from association, it would be authorised by a G4S manager, yes?
Yes. Yeah.
And you say that was the correct process. Now, as far as you were aware, in what circumstances could G4S, rather than you, authorise a Rule 40?
In what circumstances? So if it was, I forget the word. So sorry. So in matters of urgency, for example, where the officers had to react immediately to that individual because maybe they were being refractory, they were being violent, they were perhaps even self-harming themselves.
So that was your understanding, that in matters of urgency it could be G4S?
Not necessarily self-harming, sorry, but certainly where they suddenly become... If there was, like, for example, if there was a fight suddenly between two detainees or even an assault on an officer, and other officers stepped in to immediately remove that person from the vicinity, then yes.
Yeah, but as far as you were aware, it was in matters of urgency that G4S could authorise a use of Rule 40. Yes.
Yes, in most, that's a general understanding. That's the instruction. Yes.
And would that suggest to you that it would mostly be the Home Office who authorise it, and then occasionally G4S?
I think until the DSO was written,
February 2017.
yeah, until that was written and rolled out, because I think it was updated, wasn't it, quite soon? I think there was a bit of confusion over whose name should go on the old DCF1 forms. So DCF1 being Rule 40, and there's 4 pages to it. The front one being obviously name, time, reason for, and person authorising. There was a bit of confusion over whose name should go in that box. It wasn't that clear. The DSO, I think, cleared up that confusion about the authorisation, the notification, as it was set out quite clearly
Right.
in the
So
boxes.
were you clear during the relevant period, which is after February 2017,
Yeah.
that it should be G4S, it should be the Home Office who authorise Rule 40, other than in cases of urgency, when it can be G4S?
That should be the case, yeah.
Yeah. And in your experience, was that what happened? Was it only in cases of urgency that G4S did the authorising themselves, or did they do it themselves as a matter of course?
If they were going to put someone in Rule 40 retrospectively, or the information came through to show that this person was maybe at risk from some of the population in the centre, then they might come to us and say, we're worried about this person, we might move him to Rule 40. This is before E-Wing, obviously. They might move him to Rule 40.
But why are you saying it retrospectively? What's the relevance of that?
What do you mean?
Well, I'm asking you whether, when the decision is taken to put someone on Rule 40,
Yeah.
which you've said should be the Home Office unless it needs to be done urgently,
Yes, yeah.
I'm asking you, was that what happened? Was it the Home Office who did the authorising, other than in cases where it was urgent?
It should have been, yes.
Okay, and was it?
As far as I recall, yes.
You say in your statement that where it was to be done by G4S, it should be done by the G4S manager. What was your understanding of who from G4S could authorise use of placement on Rule 40?
I think it was a detainee custody manager.
And in cases where you were doing the authorising, and there are cases we've got where you personally authorised placement on Rule 40, how did you satisfy yourself that the terms of Rule 40 were met?
So they would explain, whoever was asking for authorisation to relocate that person to Rule 40 accommodation, they would set out why they wanted to do that and what the need was for that.
And you would read the papers?
If I wasn't on site, they'd read it out to me, or they'd say what they were going to write.
Okay. And how would you satisfy yourself that it was necessary in the interests of security or safety?
Well, if it met the threshold of that, then
So
that would be.
you'd presumably take what G4S told you at face value?
Yeah, if it was over the phone, then yeah. What? Yeah.
Did you ever receive training about placement of detainees on Rule 40?
There was no training, no.
So when the new DSO came in that we just talked about, you weren't trained specifically on that?
I think training came later.
Okay. I want to move on to the issue of your interaction with the Gatwick Detainee Welfare Group. Firstly, on the issue of the draft Memorandum of Understanding, you talk about it having, in your statement about it having been agreed and finalised with GDWG in February 2016.
Yeah.
The evidence the inquiries received from James Wilson of GDWG and Dan Houghton from G4S
Yeah.
is that the Memorandum of Understanding was never agreed. It continued to be a draft. Is there any reason why you say it was agreed?
The one dated February the 16th.
You say February 2016
February 2016. Yeah.
that there was a Memorandum of Understanding, and you say that it was agreed.
Yeah, it was agreed. Yeah.
The other evidence is there's no evidence to suggest that it's agreed. Or on what basis do you think it was agreed? Is the question.
So there's an email from Nick Eady, who I think was the previous director. In fact, he was the previous director at the Gatwick Welfare Group, to someone at G4S, who said, who then forwarded the email to me from him saying that he was happy with the MOU. Let's go ahead and sign it.
Well, we haven't seen that, so are you able to access that email?
Yes, yeah.
Okay, if you can provide it to the inquiry in due course.
Yeah. Apologies that hasn't been disclosed.
Now, before we get into some of the specific meetings that you had with the GDWG, you were asked why exceptional circumstances were required before it was GDWG were allowed to have repeat visits with staff. Do you remember that?
Yeah, yeah.
And you say that there was a difference between the drop-in surgeries and volunteer visits, and that the visits, the drop-in surgeries, you thought it was reasonable to clarify why they needed the second one of those. Is that right?
Okay. Yes.
But what was the problem with having repeat visits? What was your issue with it?
There was no problem. They did have repeat visits.
Why did they need to show exceptional circumstances to justify? If they thought it was in the interests of the detainee and they were trying to help the detainee, why did they need
Do you
exceptional
mean
circumstances?
the drop-in,
Yeah,
as opposed to the
as
social
opposed
visits?
as opposed to volunteer visits.
Okay, because there was no restriction on the social visits.
I'm asking you about the drop-ins.
The drop-ins, I don't know why that was ever in the MOU. It must have been a discussion that G4s had at the time with the previous director, because he wanted to trial. From my recollection, the original reason for the meetings or the drop-in surgeries was to try and match up the volunteers with the people who were detained appropriately, be it language, age, interests, I don't really know. And that was the understanding at the time, and I think I came into that kind of agreement a bit later.
Did you personally see there to be any reason why they had to show exceptional circumstances to have a second visit?
No, I think they had to ask G4s that they wanted to see this person again and set out the reason.
Why?
I don't know.
So there's no substantive reason that you can give for it?
I think it's because their role was a befriender service, or their role is a befriender service, and the point of the surgeries or the drop-in bits was so that they could match them up with the volunteers. That was the reason, that was what the MOU, I think, is clear on, isn't it?
Well, it's their clear evidence that there was no agreed MOU. And if they are saying that, if a member of staff from GDWG is saying that I want the second visit to see this person again because I think it will help him, why do they need to show exceptional circumstances for that?
I don't know.
Okay. Did you personally see any problem with the GDWG signposting detained people onto other agencies such as RAPT or the Forward Trust?
The ones that were based in the centre?
Yeah.
No.
Okay. And there's some evidence from Dan Houghton, who's giving evidence tomorrow, who says that the Home Office and Ben Saunders were concerned that GDWG were trying to offer legal advice. Was that your view?
So there was a couple of cases where it was reported to me. I don't know who reported to me. One, I think possibly came from the interview corridor, where someone who had volunteered to leave the UK for the voluntary return process, following a meeting with someone from GDWG, had then come out and changed their mind and revoked their voluntary return disclaimer form. So it was just something that was raised, and I wanted to ask GDWG if that, if they were giving that type of advice out.
I mean, they were very clear throughout that they weren't giving legal advice. Was your concern, based on the example that you've just given, that the Home Office were getting in the way of the that GDWG were getting in the way of the Home Office's attempts to remove people from the United Kingdom?
I don't think they were getting in the way. I mean, there was another example, and this is two examples out of, and I'm assuming, hundreds of people that they saw, so very, very low. But there was a caseworker, I remember they rang me and said, someone from the Gatwick Welfare Group have rang me to say that the flight needs to be stopped. So, and I can't find that anywhere. I don't know if it was a phone call, but I remember seeing notes on SID at the time to that effect. But I can't find it for the
And do you remember was that several years before the relevant period?
I don't know.
Okay. Now, in the relevant period, or around the relevant period, there's a few meetings that I want to ask about briefly. March 2017, June 2017, August 2017. The first one in March 2017. One of the issues that was raised by you was that a member of GDWG staff, Naomi Blackwell, had given a witness statement in support of a detainee back in 2015, so around 18 months earlier.
Yeah.
And you say in your statement, Mr. Gasson, that you recalled that senior management of the Home Office were aware of this, and there was a concern about the level of detail and a request for clarification. What was your concern about the level of detail?
I've never read the witness statement. I don't know, but it was.
Who was it from the Home Office senior management that raised the concern with you?
I think my manager at the time, who was someone completely different to.
Who was that?
if it was someone called Sally, I can't remember her surname, Sally, someone, she was aware of it, because...
This is in 2017 I'm talking about.
Oh,
You raised it in March 2017 about a witness statement that had been completed in October 2015.
I don't recall raising that then at all.
Okay, well, you say in your statement that you don't recall mentioning the statement,
Okay.
but it was recorded by GDWG at the time. Were you aware of the concerns about that statement?
Aware of the concerns, what, from the Home Office?
Yeah.
If I had any? No, I wasn't aware that there was particular concerns.
Was this part of you, on behalf of the Home Office, trying to dissuade GDWG from supporting detained people?
No.
In relation to the June 2017 meeting, it's alleged by James Wilson that you personally expressed displeasure that they were using drop-in surgeries to do casework. Why would that be a problem for you?
What casework is he talking about?
Well, you're the one, you expressed concern about them using the drop-in surgeries to use casework. That's the allegation.
It seems, if that was I don't remember that, but if that was the case, then it might have been based on those two cases that I mentioned.
Which were several
earlier.
years before.
It
Why
wasn't-
would you be
was-
raising it?
Well, it wasn't several years ago. Several years before.
When were
I was
they
in Brook
then?
House for several years. It would have been one of the emails that is sent says the date, that because I think in his response he talks about that there was no GDWG visitor on that day and they didn't see a certain national, whatever that the person's nationality was. So that put that to bed. So it was a concern that had been raised locally, and I felt it was appropriate to ask that question to him.
There was a meeting in August 2017 between you, Steve Skipt, and James Wilson, and you'll have seen that James Wilson alleges that during that meeting you were hostile with an overbearing tone, you became very heated and were shouting at points, and that you threatened to remove their drop-in surgeries. Do you accept that?
No.
He wrote an email at the time, on the same day, after that meeting, to his colleagues, which we've heard in evidence, saying that the continuation of the drop-ins is on something of a knife edge. Can you think about why he would be saying that to colleagues immediately following your meeting?
I don't know. I mean, from my recollection of that meeting, he had emailed at least twice asking to sign the MOU. It was an opportunity for him to amend the MOU, add additions to the MOU, how he wanted perhaps the surgeries to go. On that email from him, I think it's 25th of June 2017 or 26th of June, he's emailed myself, probably Steve and Dan as well, saying attached is the draft MOU. The Board of Trustees are happy that I go ahead and sign it. Can we get together and sign it? For whatever reason, we didn't go back to him quick enough. And then the following month, he said, I'm quite keen. I think it was in July. So my understanding of the meeting in August, 18th of August, was to sign that MOU. But I think, and this is me, I think there was only one meeting in August. I don't think there was another one. Was about that MOU and whether or not they wanted to add anything to it, because with the current MOU, which I am quite sure was agreed back in Feb 16 with the previous director, this was his opportunity to change anything. So there was no real point in three people signing an MOU and then us revisiting the same sort of things that were coming up again. If he wanted to maybe expand what GDWG did, he didn't really seem to know what he wanted from the surgeries.
Right, Mr. Gasson, but
But-
I'm asking you about the August 2017 meeting,
Yeah.
and his evidence was that you threatened to remove their drop-in surgeries at that meeting. Did you do so?
I don't remember myself or Dan or Steve ever saying that. The MOU was still in place. The current MOU
Well,
the one that was signed
know
in
that
February 2016 was still in place.
Well, we
and
know
that
there's a
would
dispute
that
of
would
evidence
remain in
about
place,
that.
wouldn't it?
Sorry. Sorry. We know there's a dispute of evidence about that, Mr. Gasson.
Okay.
You say there's a signed one, but we don't have evidence of a signed MOU.
Okay.
So you have a meeting in August 2017. There's still, according to GDWG, no signed MOU.
No, but James was keen to sign it.
Okay. And then at that meeting, he says that you were hostile, you banged the desk, you were shouting at points, and you threatened to remove their drop-in surgeries.
No one banged a desk.
He said that, in hindsight, the approach from both you on behalf of the Home Office and G4s was tantamount to bullying. Do you accept that?
Absolutely not. I mean, we were simply asking him to clarify his vision for the surgeries and the role of the company, that his charity that he was the director for. At times, I think, from memory, certainly in the first 2 or 3 meetings, which might have been all of them, he didn't really seem to know what the people were doing who were coming in, and we did ask for clarification, and I think that did finally come through about 5 or 6 weeks after this August the 18th. He wrote it. I never received it. I've only seen it as part of this inquiry. I seem to be CC'd onto a letter, so I'm not sure how G4S received that or how it was sent. Was it sent through the post because it looked like it was a letter, or if they received it by email? But I've checked my inbox and I can't find anything on that date that clarified the drop-in surgeries or what he wanted.
Looking back, Mr. Gasson, do you consider that your approach to James Wilson and GDWG during the relevant period was a reasonable one?
I do consider it was reasonable. I mean, they were fairly short meetings. There was about 4 of them over the period of a number of months. You know, and with all due respect to James and the GDWG, they were, you know, they didn't feature that prominently on my radar. I was aware that they came in and they did a very valuable service to the people who were detained. I think that's referenced in one of the emails. I think he actually quotes one of us saying it, how valuable their service is, and it really was. There was no issue with them coming in on social visits. We just wanted clarification around the drop-in surgeries and what they actually did in there. Because we'd made some good progress, or G4S had made some good progress with GDWG in the run-up to 2015. The person in place at the time, a guy called Chris, because from the email I remember, he had offered to walk around Nick and his colleagues around Brook House, an offer which he took up, and they took a tour around Brook House. But James Wilson talks about building a relationship and that, which is fine. As far as I was aware, looking at the emails, there was nothing in his emails, in any of his emails, to show that in any way, shape or form he felt anything that he says in his verbal and witness evidence. If that was the case and he felt that way, of course, I can only apologise that I made him feel that way, but I cannot think of anything that myself or even Steve or Dan said in that meeting that may have made him think that way. We were just simply asking for clarification, and he didn't seem to be able to tell us that was...
Okay, just 1 second, Mr. Gasson, sorry. Mr. Gasson, just a couple of final questions, if I may. You had a role after Panorama of being responsible for removing the certification or revoking the certification of staff who had been caught up in Panorama, yes?
Yeah, it wasn't a new role, it was part of the existing DSO.
And you recommended the revocation of certification for a number of staff, is that right?
Yep.
And you talk in your witness statement about the shock that you felt at the behaviour documented in Panorama. And you say that what added to your shock was that not a single member of G4S senior management team was aware of what was shown. Given that you were present almost every day at Brook House, were you also shocked that you were not aware of it?
I was
And
shocked. This is a complete surprise.
And do you consider yourself to bear some responsibility for not having spotted what was shown on Panorama?
I mean, if I'd seen it, if I had an inkling from it, I'm just surprised that it didn't come out, because there are several instances where staff have raised concerns around the conduct of other staff, and G4S were very quick to act in those instances. They notified us being the Home Office on site and also the certification team, if they had suspended someone. I'm just surprised that no one who had witnessed that the incident or incidents had raised it, because I thought that there was a culture, if I'm honest, and based on several examples of where people had raised concerns around conduct of their fellow officers, and that was investigated by G4s. I'm just surprised the number of people, especially with the obvious incident where the person was being held down and it looked on video being choked. It was absolutely shocking that, one, that happened, and two, that no one took it upon themselves to report it, or even try to report it through either the whistleblowing process or through the SIR process, or even going up to the senior management office and saying, I've just witnessed this.
Mr. Gasson, I've got no further questions for you. I'm not sure if the chair has any questions.
Thank you, Mr. Livingston. I do have a couple of brief questions for you, Mr. Gasson. The first, you mentioned early on in your evidence that it was sometimes difficult to get raw data from G4s. Can you tell me a bit more about that, please?
Yeah. So obviously when we received the staffing figures, we had one set of figures. We had nothing to compare it to. We need, as a monitoring role, we needed to compare the raw data with what we've been presented with, because it was an Excel sheet. No way, shape or form am I saying that had been manipulated, but I mean, we needed to satisfy ourselves that the minimum staffing requirement was being met. And it was actually one of the deputy immigration managers who actually resolved it when we asked, and I think it was prior to Ben coming in, when we asked the previous director, can we have these figures? He said it wasn't available. So my colleague, the deputy immigration manager, walked through to the G4s admin office and asked the staffing manager if we could have it. And he went, yes, you can. And it was as simple as sort of pressing a button on what was called the Chronos machine. And following that meant that we were able to get those daily, and then we cross-referenced that with another step that we built into the process, whereby we asked to see the daily briefing sheet where officers were in the actual centre, and then part of the due diligence on not just me but also my colleague who as I said earlier was focused more on the staffing, was if someone appeared on the staffing sheet who perhaps was meant to be in reception, or for example was on the raw data but wasn't on the staffing sheet, or had clocked in but didn't appear on the Brook house, we wanted to know why that was. Why was someone working 15 hours? One, it's probably a little bit inappropriate for somebody working out, and then we worked out that some people would come in early and use the gym, or use the gym after they'd finished work, which was maybe skewing the figures. So we wanted to make sure that the hours that we were presented was the correct hours, so we could do the contract monitoring and pass up those numbers.
Okay, thank you, Mr. Casson. Then the other question I have is in relation to, you talked us through again earlier on in your evidence about the routine that you established to check on some of the things that you identified as being useful for you to do so. Yeah. Where did you kind of compile that list of things that you were going to check on? How did you come up with that approach?
Just over time, I had different routes through the centre. So I would drop down to the interview corridor, for example. I would see if our staff were okay, see if there was a number of G4s staff, see if they were bringing staff out in time for the immigration staff to be able to engage with them, serve paperwork, update them on their cases, etc. I'll check the bell rooms are open. There's 2 bell rooms, people having bells. There was a couple of instances where I'd had a call from the court clerk to say, why isn't the bell running? The judge, you see, I've been reprimanded a couple of times by a judge. Why? Not my responsibility, but I made sure that I was open. Then I would maybe go into social visits, make sure that it was generally clean. There was an ACDT folder behind the desk, which meant that staff in there knew that if anyone was in the visitors area seeing a relative or a family member, they knew that they were on ACDT. So I'd go to different areas. So there was no real structure. There was no real sort of framework.
Thank you. I don't want to cut you off. I'm very conscious that the transcriber desperately needs a break from typing. Yeah. That's very helpful. Thank you. I guess the only follow-up question to that really is that, did you have any specific training on how to monitor a contract? Did you talk to other contract monitors? Was there any kind of guidance as to this is what you could look at, these are the methodologies that you could use?
Sorry, I've got cramp. From recollection, when we first started, so before Brook opened in March 2009, I went across, and I think it was in November 2008, and spent time in different IRCs, established IRCs, both for the contact management role, because I'd never sat opposite someone who was detained before. I used to be a caseworker. I'd never physically sat in a room opposite someone who, and then the contract monitoring. And at that period of time, there was a proper piece of software for contract monitoring, and it reflected all the parts of the contract monitoring, and so you could go around and physically go around and check each part. That, for some reason, that dropped off. So early in, or mid to late 2009, we made our own one up. So the parts of the contract which we also have in PDF, we would have those, and me and another deputy immigration manager would rota an AO member of staff once a week to go out and about and check the contract against what was happening. So it might be the security, they might check the PIDs, which is the perimeter intrusion detection system was working, the CCTV was working, and then the following week another member of the contact management team would do the contract monitoring, and that was still in place when I went to Harmondsworth in August 2011, and I think in that time the centre just got a lot busier, and I think that dropped off.
Okay.
But me personally, I would pick up, walking around the centre, walking around the different areas, I would note what I'd seen and bring those in as part of the weekly meeting with G4s. And some might have been Schedule G, some may have just been Schedule D. Anything that I may have noticed that may have caused a concern or something they might not know about. But the IMB also fed in to, they were also our kind of eyes and ears sometimes as well, in terms of...
Okay, thank you. Thank you, Mr. Gaston. I have no other questions. Mr.
Chair,
Livingston, anything else?
I have two very short things, but the stenographers, I think, are struggling. Would the stenographers prefer that we have the break now? It's literally two questions.
Okay, just speak one at a time.
Okay.
You have been warned.
I have, yeah, many times. If we can bring up on screen, please, HOM 000798. At page 147. This is another version of the Schedule D, which I brought up earlier. I'd asked you before, Mr. Gasson, about what the relevant failures would be in relation to reporting a self-harm injury. Was this the procedural matters that you were talking about?
Yeah, that's pretty much the only thing in Schedule D that related to laid out procedures, from what I can, from my recollection and from looking through the contract.
Okay.
I think you said yourself you couldn't find anything.
And one final question. I asked you in relation to Rule 40 about the circumstances in which G4s could authorise it rather than yourself. And I asked you who the relevant manager was from G4s, and you said that I think it was a DCM. Do you remember how you formed the view that DCMs could authorise Rule 40?
I think they did it on behalf of the manager, so I think that was a delegated responsibility that perhaps they were given.
And do you remember how you understood that to be the case?
I don't.
Chair, I've got no further questions, and I'm sorry to the stenographers, always. Thank you, sir. Chair, we are due to still have another witness today, Vanessa Smith. Can I suggest, would you like a 15-minute break? I think we'll have to be a 15-minute break.
Mr. Livingston, I think we'll say 15
yeah,
minutes.
it'll have to be a 15-minute break.
Okay, thank you. Thank you, Mr. Gaston. I know it's been a long afternoon. It's not an easy experience. I'm very grateful for you coming and giving your evidence. Thank you.
Very much.
We'll see you at 4:15. Thank you. Thank you very much.
I swear by Almighty God
That the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
and nothing but the truth.
Please take it, Ms. Smith. Thank you. Ms.
Chair, I will end this afternoon's evidence with the evidence of Vanessa Smith.
Thank you.
Ms Smith, please could you give your full name to the inquiry?
It's Vanessa Smith.
And is it correct that you've provided a inquiry witness statement, which is HO0M0332141?
That's correct.
And Chair, I'd like this to be adduced, please, today.
Thank you.
Ms Smith, I want to ask you first about your roles during the relevant period. Firstly, before the relevant period, from May 2013, you started as a Home Office Brook House Administrative Officer. Is that correct?
That's correct.
And then from October 2016, you moved to the Engagement Office within the Pilot Pre-Departure Team,
That's correct.
which then became permanent around the 4th of October of 2017.
That's correct.
And since then, is it correct that you've remained at Brook House?
That's correct.
There are two teams, you explain in your witness statement, paragraph 7, at Brook House for the Home Office. The first is the Pilot Pre-Departure Team, now known as the Detention Engagement Team, and the second is the Contract Monitoring Team.
Yes, and they are called DES, Detention Escorting Services.
Compliance Team.
Compliance team.
Yeah. And in terms of your evidence today, that's going to focus on the Detention Engagement Team.
Yes.
Do you know why that name change from the Pre-Departure Team to the Detention Engagement Team?
To be honest, I don't know.
So you worked in the Pilot Pre-Departure Team, as we've said, and that involved meeting residents and building a returns plan. You discuss their position and try to identify and resolve barriers to return. You also explain in your witness statement, paragraphs 100 to 101, that in the case of non-compliant removal, so where detained persons didn't want to go, then you might ask someone from G4s to be present if there was concerns that that person would be violent. You also say that there will be a list of people and they would be on a raised concerns if RDs, presumably removal directions, were served. So just so that I can understand, we can understand what that means is if somebody was given removal directions, you would be present at the time that they were going to be removed from this placenta. Is that right?
No, that's not. It's what I meant in my statement was when I'm serving the flight ticket, if I knew they were going to be disruptive, looking at their notes previously, knowing that they're not going to be non-compliant, I'd have somebody outside the interview doors, just in case they do become disruptive when I'm giving them their tickets.
When you say people, do you mean detention centre officers?
Outside the corridor would be the G4s officers. I would tell them to just be aware that he might be disruptive if I'm serving him his ticket.
And was this the process that was in place in 2017?
Yes.
And when a person was physically going to be removed after you'd provide the ticket and said that they were going to be leaving, at that point, was there anybody from the Home Office present?
I don't think so.
I want to ask you now about detainee forum meetings. You say in your witness statements, paragraph 19 to 20, that when they were in the pilot stage, that you would attend these detainee forum meetings with the compliance team. When were these detainee forum meetings in their pilot stage?
When we first started, it was a trial and error to see what things worked, because we were in a pilot. So we would attend these meetings to see how it went. But as I said in my statement that we stopped attending those meetings because it was not relevant to us, only because they were asking us case information, which shouldn't be shared with other parties because of confidentiality. We couldn't discuss cases, hence we did the drop-in sessions.
And when you say that we stopped attending, do you mean both the pre-departure team and the compliance team,
No.
or do you just mean the pre-departure team?
Just the pre-departure team.
What kind of issues did detainees usually raise in these detainee forum meetings?
Mostly about food issues and not having this stuff. And for our point of view, like, why are they still detained? They were trying to ask us questions, which at that point we couldn't answer. So that's why we, as I said, we did the drop-in sessions to give them more in-depth information that they required.
And did detained persons ever raise issues with no-notice charter flights?
Not that my knowledge, I don't know.
Was that something that your team dealt with?
You mean by no notice?
Yes.
It was more to do with compliance who dealt with the no notice, because my job is to serve the paperwork, but if there was no notice, then we wouldn't be involved in it.
I see. I want to ask you about 3 specific incidents now. The first relates to a training session that took place on the 22nd of February 2018. Zainab, I'd ask please to bring up H0M005901. This is a G4s investigation report into 2 comments that you made at a personal safety training course held at Tinsley House for members of staff, 3 of which were from an organisation called Hibiscus. Can I check first, do you know if you were the only person that attended from the Home Office?
To my recollection, at that point, yeah.
If we could please turn to page 5 of that document. We'll see in the middle there is an allegation 3, which says, in reference to an incident on Monday night where an officer had punched a detainee in the face, several detainees had barricaded themselves in their room and had weapons and had made the floor wet and stopy. An officer was apparently the last one standing and punched one of them. Vanessa from the Home Office said he deserved it and had it coming, and then someone said, we don't say that, Vanessa. All of the Hibiscus employees interviewed on the 27th were clear and consistent that this conversation had taken place as described. Since the allegation relates to a Home Office employee, the investigating officer is due to meet with the Home Office representative on the 1st of March 2018 to discuss. In brackets it says substantiated, yes. So this is the first 2 comments that were made, that were investigated, that were made by you. If we can turn to the second one, which is allegation 12, which is on page 8, please. So Vanessa from the Home Office seemed to have a very negative attitude towards detainees. This was shown through laughter at comments she made herself, and her general attitude to violence. For example, comments, I'd go to town on them. All 3 of the Hibiscus staff report a significant level of concern around the behaviour of Vanessa, which will be raised by the investigating officer with her immediate line management at the Home Office on the 1st of March 2018. Substantiated, yes. You were then subject to a formal disciplinary meeting on the 24th of April 2018.
That's correct.
Then please could you bring up that document, the disciplinary minutes. It's H0M005901. It's the first page, please. So this was the investigation, G4s investigation. And it's page 1, please. I'm sorry, did I say 5909? It should be the last. I'm sorry, I said the wrong number. It's H0M005909. Thank you. These are the formal disciplinary hearing minutes. Page 1, just if you can the bottom paragraph that we just saw, so in the middle of the page, SL advised that the investigation had found that there was a clear case, that there was a case to answer in relation to the first allegation, as VS, Vanessa Smith, had admitted to saying these words. So you admitted the first allegation, is that correct?
That's correct.
And that first allegation was substantiated and you were issued with a 12-month verbal warning. But the second allegation relating to the comments, "I go to town on them," and having a negative attitude towards detainees was not substantiated.
That's correct. But I would like to highlight the first allegation was taken out of content. That's why I admitted it.
We'll come on to that in a moment. Thank you, Ms. Smith. In terms of the discipline outcome letter, I won't ask to bring up that on screen. But that said, as I said, the second allegation was not substantiated. But that's in contradiction to the G4s investigation that we saw and brought up on screen earlier. It said it was substantiated. Do you know why there was a difference between the investigations and the results of those?
I'm not sure, because when I had in meeting with my manager, because I think the evidence that they had or the investigation they took, the witnesses that were there said that I never had that attitude, I think.
But do you know why there's a difference between the two different investigations' outcomes? One said that the second allegation was substantiated, the first one, and the second said it was not proven.
Not that I know of now.
I want to come on to your account with regards to the first allegation. You said in your witness statement, paragraph 31, that you'd been expressing yourself colloquially and it had been taken out of context and the meaning had been misunderstood. You said that what you meant was that the actions were justified in the circumstances. So you were said to have said he deserved it and had it coming, and this was in relation to an officer having punched a detainee in his face, where a detainee had barricaded himself in a room. This was in the personal safety training. Do you accept now that that was a poor choice of words?
Yes, I do.
And would you agree that if you said that the detainee had it coming and deserved it, this suggests that it was a punch to a detainee that was in revenge rather than a defensive strike?
As I said in my investigation and in my statement, that it was a scenario that was played, and I was thinking of the scenario when I made that statement in the language that was used throughout the investigation. And it was what I meant to say at that time, that it was justified because it was an officer who was under threat. Because in that scenario, all the officers were down, the floor was soapy, the resident had a knife or a weapon, and it was a live threat situation, and the officer made that punch.
But if you said someone had it coming or deserved it, that suggests that someone had retaliated rather than that it was a defensive strike. Would you agree with that?
Can you explain what you mean?
So you said that the detainee had it coming, they deserved it,
Yeah.
which suggests that someone was retaliating, responding in a revengeful way, that you hit me, I hit you, as opposed to I'm protecting myself.
As I said, it was a poor choice of words that I used at that time, bearing in mind the language that was used throughout the day.
When you say bearing in mind the language that was used throughout that day, what do you mean?
So it was more informal, colloquial language and more casual language, and I guess it was a poor choice of words that I used at that time.
The suggestion isn't that your language was too colloquial or that it was too informal. It was that it wasn't appropriate because you were suggesting that somebody deserved being punched in the face.
I didn't mean he deserved being meant. I just meant that it was justified.
You were the only person from the Home Office there. You confirmed that a few moments ago. Do you agree that this does not show leadership?
At that time, I was training, so I was a trainee in that environment.
You had been working at the Engagement Office since October 2016, and the training was in February 2018. So there was over a year where you were at Brook House. So was this the only training that you'd had in relation to use of force or rather
Yeah.
personal protection, I should say?
Yeah, so basically PST is done yearly. So personal safety training is done yearly, on a yearly basis.
So you hadn't had it in the over a year that you'd been there?
No, I've had it previously, yes. When I started, we have to be PST trained in order to see residents.
So you said you were in training, but you had in fact had this training before?
Yeah, but with G4s
So
I
should-
believe it was for the first time.
So if you'd had that training before, shouldn't you have known better?
Recollecting, I agree that I used a bad choice. It was a bad choice to say what I said.
In terms of the second allegation, I go to town on them and having a negative attitude. You've denied that in the previous investigations. Can you think of an explanation as to why the people from Hibiscus might have made that up?
I don't know.
You accept that in your witness statement, paragraph 33, that due process was followed and a sanction was issued. Do you agree with that?
Yes, so I was investigated and I accepted what was sanctioned to me.
If we can place one of these documents we've already looked at up on screen again, it's H0M005901. This is the G4S investigation, the first document that we saw on screen. And if we can look at page 1, please. Apologies, just if you could just go to page 3 and just roll over the page, please. And again. We can see the allegations there that were set out. There were 2, as I said, that were concerning you, but there were others that concerned 2 your use of force trainers, which were David Webb and Jason Riggs. You can see the first allegation is, "I'm going to fucking destroy you," which was said multiple times by the instructors. Jason also said at one point during the practical training, when referring to reacting to a detainee attacking you, to use, and it's Dave's favourite line, we have this unredacted elsewhere, I'll fucking destroy you. Then allegation 2, if it was down to me, give them one more punch for luck. And those 2 were substantiated. If we go to allegation 4, which is page 5, in fact the same page, just down there, the instructors said that the punches taught in the syllabus are never used because they don't do anything. They said they would just punch in the face. And then if we go to page 7, and it's allegation 11, so just scroll down, please. The instructors were teaching the phrase "fuck off" from the beginning of the training as a way of defending yourself. They were swearing you throughout the training, which was, in our view, unnecessary. However, an instructor did say at the beginning of the training that there would be swearing and that we should speak to him if we didn't like the use of swearing. Nobody raised concern with him about the swearing, but we felt the level of swearing was unnecessary and we don't feel it added to any training. Just scroll over the page, please, at the top. Substantiated, yes. You said earlier in your evidence just now that you were reflecting language that was used. No one is suggesting that you were swearing or saying those words. But what did you think when you were hearing that kind of language used talking about detainees?
To be honest, because it's been such a long time. I don't know what my reaction was at that time. I was just listening to what the instructors were saying. I didn't make any comments on that.
If you heard that now, what would you think?
I would definitely say something.
And do you know why you didn't say anything at the time?
To be honest, I don't know.
I want to ask you now about another incident in relation to D687, and in particular your failure to open an ACDT for him on the 27th of April of 2017. If we can please turn to Zainab's H0M032193, that's the first page. You'll see just from midway down the page, the date is the 27th of April 2017. Just please scroll back to the top, please. You see that these are your notes. I see from the signature there, Vanessa Smith. Is that right?
That's correct, yes.
And these are GCID notes. Can you just very briefly explain what GCID notes are?
So it's an immigration database where information is stored of the interactions and cases.
And who usually writes on these GCID notes?
So there could be anybody in the Home Office, for example, engagement officers. They could be caseworkers. So mostly the people who deal with the cases.
And what type of information should be recorded on these GCID notes?
So the interactions that we have with the residents or anything to do with the case, the updates on the case or what is going on with the cases, so we can, basically engagement officers can read where the case is at.
So you see at the top there, you've written, detainee has stated that he will not return to Somalia. He will only go back to Somalia in a body bag. He was staying strong for his mum as he lost his brother a few months ago. He can't take it anymore as he is mentally stressed of being in detention so long. He has started to write a suicide note. He is going to give it a week, and if things stay the same, he will do something. He then stated he is not going to be coming for his paperwork. G4s officers and immigration managers warned of his intentions. This conduct was investigated, and you were required to provide a witness statement. If you can please get that up on screen. It's H0M002501. It's page 1. You'll see there in the middle, this is your statement, your brief statement about it, and it says in the middle of the page in black writing why you did not open an ACDT.
Yeah.
And the response is there, I didn't open an ACDT as I managed to calm him down by explaining the procedures of immigration, but informed that managers to make them aware. The G4s manager spoke to him and didn't feel it was necessary at that time. Later, a Part C was raised by DCM Rufi at Brook House. ACDT was opened on D687, and he made threat to take an overdose to the RAP team. Brook House mental health team aware as well. And then if we can turn to your interview, please, on the 24th of January 2018. That's at H0M002505. That's page 1, please. And it's the middle of the page, starting Miss Smith. Miss Smith said the detainees would say things like this out of frustration. She would assess the comment by looking at the body language and deciding if they really meant the comment or not. If they were shaking and of low mood, she would open an ACDT. She could not recall D687's actions that day, but if it had been serious, she would have opened an ACDT straight away. She thought he was just saying it through frustration, so she had told G4s and immigration managers, and G4s spoke to him. Miss Smith said the conversation would take place and she would not have been present. They did not put him on an ACDT, so she assumed D687 had calmed down. She could not remember the feedback from G4s. She could not remember if she had emailed the caseworker as well, as put the note on CID. You said in your witness statement, paragraph 44, that you agree asking him to stay in his room and asked a member of staff to be with him. Is that right?
That's correct.
Would you agree that this interview and your statement was done closer to the time that this happened?
Sorry, can you repeat that again?
The interview that took place with Helen Wilkinson,
Yeah.
which is what we've just seen on
Yeah.
screen, and what I showed you a few moments ago, which was your statement.
Yeah.
Those were made closer to the time of the incident on the 27th of April 2017 than today's date.
I'm sorry, I can't understand. So you're saying the first statement you showed me and this one now?
So the statement that I showed you a few minutes ago,
Yeah.
which had the red writing
Yeah.
on,
Yeah.
yeah, and what I'm just showing you
No.
here,
Yeah.
your account that was taken then,
Yeah.
that was quite soon after the incident happened, wasn't it?
I think so, but I'm not really sure.
I say quite soon. The incident happened on the 27th of April, and this document here is from the 24th of January 2018, so around 9 months later.
I don't know what to say to that.
I'm just giving you the context of the question. I'm explaining the question to you. So
So this April that the red bits thing was done, and then this one.
no, the incident happened
Okay.
in April.
Yeah.
And your account that you've given was in January 2018. So that was about 9 months later.
Yeah.
Yeah. Today, now,
Yeah.
that is much further in time
Yeah.
than when you were between the time that that the incident happened in April and when you gave your account in January 2018.
Yeah.
So it's likely, isn't it, that that information that you gave to the investigator, both in your statement and your interview, was more accurate, would you say? Because it was closer in time.
It was closer in time, yes.
So why didn't you mention in that interview or the statement that you told him to stay in his room and that you asked a member of staff to be with him?
That was a process that we normally follow, so I'm not really sure why I didn't add it on.
So are you saying that this happened because it's the process you normally follow, or because you actually remembered that it happened?
It's normal process that we follow.
But do you remember it happening in this instance?
I do remember happening that, like, I told him to stay in the room. Then I would get the process without telling him to stay in the room. I would get the G4s visit officers to keep an eye on him and tell them to inform the Oscars, which is the G4s managers, to have a word with him after. And then I went up to the office and I told my managers, as I've explained in my SID note, that this is the process I've done after I have informed them, and I'm waiting for G4S to come up to tell me whether an ACDD should be opened or not, if they have settled him or not.
Do you know why that you didn't mention that normal process and the process that you said that you did do in this case in your interview or in your statement that was closer to the time?
I don't know really.
You said you spoke to managers. Do you know exactly who you notified?
Yes, managers as in G4S or Home Office?
Both.
I told the visit staff to inform the G4S managers and to get them present, to get them into the visit. And then I went upstairs and spoke to my manager, who's Simon Levitt, and I told him about what I've done basically.
So the visit staff, do you remember who that was?
I don't know who that was.
And do you know actually what happened, whether they did in fact go and speak to D687?
To be honest, no. I don't think I heard back, so I assumed they managed to calm him down.
You say that you managed to calm him down. Yeah. I just want to take you now to D687's account of what happened. It's please could I ask Zainab to bring up DPG 000021, and it's pages 62 at the bottom. So this is the witness statement that D687 has provided to this inquiry. And this is what D687 says. I'm reading from 6 lines down, from the top of paragraph 172. I do not remember feeling calm after my conversation with Vanessa Smith. As she suggests, I had told her that I asked for help, but no one wanted to help me, not the nurses, not the officers, so I would just die at Brook House. I told her it would be the last monthly progress report. It would be the last monthly progress report she would give, as I'd be dead in the month. She told me she told me what their rules are, that I'd be going on a flight once I had a ticket. Her concern was serving the paperwork. She wasn't interested in whether I lived or died, and that came across in her dismissive attitude. She didn't even tell me what I wanted to hear for the sake of encouragement, just what she had been told to tell me. Here is your monthly progress report, lump it. She made me more pissed off, more angry as I was walking out. She made it worse. She said things like, I'm just a messenger, been told to pass it on to you, whatever it is. You'll need to lump it and deal with it. There's nothing I can do. I'm not here to help you. I'm just here to serve you with this. And I'm not your caseworker, so I can't help you. But you never see your caseworker, and the person giving you a report can't answer any of your questions. She didn't say anything encouraging about appeals or anything changing. She wasn't there to help me. Part of her job was not to give me hope, so I give up and sign papers to go somewhere where I'd die. I thought I'd rather die quickly than being removed and dying slowly in another country. I don't know. Did you say words to that effect? I'm just the messenger, you'll just need to lump it?
I would have just told, in my recollection, I would just tell, like, in a normal residence, if anybody's like that, I would tell them that I am between you and your caseworker, and my job is to give you the information and explain it to you. But I would never say lump it. That's not a word that I would normally use. And I would try to help them out as well and give them the information. For example, redirect them to welfare, to solicitors, explaining the process of removal.
Do you agree with D687 that you had a dismissive attitude?
I wouldn't think so, no.
In your witness statement, you say at paragraph 47, in response to the fact that we saw earlier that a Part C was later opened, and that the detainee had told the RAPT team that he was going to take an overdose. You said if that had happened, if the detainee had told you he was going to take an overdose, you would have assessed the situation. Do you mean that you would have opened an ACDT?
Yes, because if the threat that he gave me when I saw him was a timely threat, and the threat he's giving now is more of an immediate threat, and I would definitely open an ACDT then.
I don't think we need to bring it up again, but we just looked at a passage in the investigation report that said that you would make an assessment of whether he was going to commit suicide or not by looking at body language and deciding if they really meant the comment or not. And you gave the example, if they were shaking, on a low mood, you would open an ACDT. Should an ACDT be opened if someone was demonstrating suicidal ideation?
If they're giving immediate suicide threats, yes.
How do you know if a person really meant it or not?
As I said, I would assess and speak to them of why they're making these threats, and if there's any way I can try and calm them down and see if I can help them out.
If someone said that they were going to kill themselves, would that help you with whether they really meant it or not?
As I said, I would assess the situation and see what their demeanour is at that time.
What about if they wrote a suicide note? Does that help you with whether they really meant it or not?
If they've already written one, yeah.
So only if they'd already written one, not if they were going to write one?
If you're referring to D687, he said at that time he gave me a time frame. He didn't say he was going to do it immediately, so I tried to help him and talk it out with him, and that's why I got my managers involved, just to put him on the radar that he's not happy with the system.
Isn't there a formal way of putting mentally ill detainees on the radar by opening an ACDT?
Yeah, that's why I spoke to the Oscars, the managers, to see whether the move I made was correct. And at that time it was agreed that I did speak to my manager. Manager said, yes, that's fine, we'll wait for G4s to see whether they will come back to us and see what they have to say after speaking to him.
So you specifically asked your manager whether you should open an ACDT or not?
No, I spoke to my manager, and as I recall, I spoke to my manager, this is what I've done. He's made this threat. I've told G4s to speak to him and then come back to me whether they believe that I should open an ACDT or not, because I believe I've calmed him down.
Do you think that you're medically qualified to decide whether a person really meant it or not?
No.
If you're not qualified, why wouldn't you just err on the side of caution?
It's because we have vulnerability training to iron out vulnerability, to see how the demeanor of person is and to assess the situation. And at that time, that was the training I got.
But if somebody says they're going to commit suicide, says they're going to started writing a suicide note, is that not enough in order to open an ACDT?
I assume now, if I was in that situation now, I would.
And what's changed?
Because we had a follow-up training after that, where one of the evidence as well says that a follow-up training was given to staff.
I'm going to take you to the training now. If we can please turn up HOM 002505, and it's page 2, please. This is an interview that you had where you speak in particular about training. Right at the top, she had contractor training on ACDTs in 2016-2017. It lasted a couple of hours and was classroom training about when to open an ACDT and how to assess whether or not to open one. It suggested that once the threat was received, the officer would then make an assessment if the person would carry that threat through or not. That would determine if an ACDT should be opened. She would send details of this. This was not refreshed regularly. Miss Smith could not remember what her thoughts had been when she had seen that the drug abuse team had opened an ACDT a week later. I should say that's not the training, that's not exactly what the training's given, but what you thought that the training had said. Is that right?
I assume so, yes.
What I mean is that's not a statement of what the training was. That was what you thought the training was at the time. Is that correct?
I'm not getting what you're trying to...
Sorry, perhaps I'm not expressing myself clearly. What I've just read to you, is that an accurate statement of what you thought the training was at the time in 2017?
What was given to us at that time, yes.
Thank you. I want to take you then to the actual policy that was in place at the time, at CGS 006380, and it's page 12. It's paragraph 2.2, second paragraph down. This is the Suicide Prevention and Self-Harm Management Policy. I just want to read one short sentence from it. It's second paragraph down from 2.2. Suicide prevention and self-harm management is a responsibility of all staff. Whenever any member of staff believes a detainee is at risk of suicide or self-harm, they must open an ACDT plan following the procedures set out in the ACDT policy. Were you aware of this policy at the time?
When we had the training, was just how to open an ACDT, how to fill up the books, and where to send it and how to report it.
But were you also trained when to open an ACDT?
To be honest, I can't recall.
Do you agree that this is a low threshold for before opening an ACDT plan?
I don't know how to comment on that because it's a contract monitoring side to do.
I'm not asking a question about the contract monitoring. I'm saying that this policy says whenever a member of staff believes a detainee is at a risk of suicide or self-harm, they must open an ACDT. What I'm suggesting to you that's a low threshold, so it's a low bar to have to meet in order for an ACDT to be opened. a person only has to be at risk of suicide.
No, I don't think so. They could be they could threat as well, I guess.
So they could make a threat.
Make a threat as well,
Yeah.
yes.
But that means a threat, we would assume, means that there is a risk of suicide if someone makes a threat. Do you agree?
Yeah, risk of suicide, yes.
And do you agree also that it should be precautionary? So you should, as I said earlier, err on the side of caution.
Sorry, repeat that again?
Do you agree that you should err on the side of caution if you're not sure
Yeah.
or not whether somebody might or might not
Yeah.
commit suicide, that you should err on the side of caution and therefore put someone on an ACDT?
We do have a process where if we think, for example, if a resident has a flight and we know he's going to be disrupted, or he said that if I have to go, I'll do this, we put them on a raised concern list so that we are aware when we are serving RDs or tickets, that we know that they're going to be in that situation, and then G4s monitors that.
And you could also open an ACDT in that scenario.
Assume so, you can, yeah.
Do you assume so, or you would?
Well, if they are threatening that they're going to do something, because if they say that they're going to do it when they're going to fly rather than when they're going to do it now, it's a bit different.
So you said earlier that it was a conditional threat that
Yeah.
D687 had made, but you can see here in the policy that there isn't anything about a time bar. It
Yeah.
doesn't say immediately at risk of suicide, does it?
No.
So do you accept now in hindsight that you ought to have placed him on ACDT?
Looking at this, yes.
I want to ask you now about the DCO David Waldock's allegations. If we can please bring up on screen VER 000061 and pages 4 to 5. This is a letter that was sent by DCO David Waldock to the CEO of G4s on the 15th of April 2017, and he was raising claims of bullying and corruption at Brook House. In terms of allegations against you, you'll see the heading there. It's quite hard to read because the headings aren't in bold, but you'll see at the top there, Gayatri Mura, and then there are several allegations. I'll read out the ones that are relevant to you. And this is another person, of course, a DCO at Brook House, DCO Marua, having Home Office officials and as personal friends in and out of work, i.e. going to parties, drinks, dinners as their guests, falsifying documents with Home Office officials for her own purpose, working with and not disclosing personal levels of friendship with Home Office officials which may interfere with work policies, i.e. Vanessa Smith being one of her best friends, talking in her native tongue with Vanessa Smith when they don't want people to know what's going on. And turn over the page, please. It should be, if you just scroll down, please. There should be Vanessa Smith, Home Office officer, perhaps on the next page. Yes. Lied to cover up bullying by Gayatri and falsifying complaint. Proof can be provided. Knowingly having a friendship with a DCO officer at Brook House and use it to influence decisions, accepting bribes and inappropriate gifts. I'll just summarise what you've said in your witness statement, if I may, in response to these allegations. You say at paragraphs 81 to 86 that you haven't seen the document before this letter, that you're probably closest to DCO Mehra. In fact, can I just check I'm saying her name correctly? How do you say her name?
Gayatri.
What's her second name?
Mehra.
Mehra.
Yes.
So you're probably closest to DCO Mehra, not best friends, that you sometimes spoke in Hindi in your regarding your personal life, and that you don't know what DCO Waldock is referring to when he said you lied to cover up bullying by DCO Mehra, or that you falsified a complaint. You say that you might have raised a complaint with about DCO Waldock to the contract monitoring team sometime in the past because it was your job. Do you know what kind of complaint?
To be honest, I didn't even know. I don't remember what the complaint was.
I want to then turn to VER 000250, and it's page 16, please. And it's question 143 and answer 144. She has popped up at all angles. People have mentioned having had an issue with her. This is talking about DCO Mehra. She was abusive to detainees, she was abusive to officers, she was abusive to her colleagues, and she abused the system. And I was just wondering whether she should have got rid of her rather more quickly than she was. It says, yes, in my eyes, possibly. Sorry, I should have explained. This is a Verita interview with DCM Dave Roffey. So the answer is yes, in my eyes, possibly. She was like a silent assassin, all smiley and lovely with management, but you were actually working there. I think there are fear amongst staff that if you said anything about Gaytree, things could happen to you. That can come down, thank you. Michelle Brown in her witness statement, I won't bring it up for time reasons, paragraph 20, suggested that you started a petition to get DCO Mehra moved back to visits. She'd been taken off visits due to an investigation about falsifying visits. Is it correct that you started a petition? Or rather, you were suggesting that you should start a petition?
I possibly did, only because I thought at that Gaytree Mehra, at visits, she always brought up our residents on time. She was efficient when home office around, and I only briefly used to see her when I used to go down for my interviews to the visit area. And then I used to go back up to the office, but in the brief time I was in visits, she always got our residents up on time and seemed efficient.
So did you suggest that you should start a petition to get her back onto visits?
To be honest, I can't recall, but possibly I could have.
Were you aware that she was abusive to detained persons and staff?
I wouldn't know that because, as I said, I only had a brief time of when I used to see her during my interviews.
Michelle Brown says that this demonstrated, this being the starting of the suggestion of starting a petition, this demonstrated to me that there is a blurred line of professional and personal relationships. Would you agree with Michelle Brown that there was a blurred line of professional and personal relationships?
As I mentioned previously, that I thought she was very efficient. She got our residents up on time, and that's why I thought she was good at the visit area.
And Dave Roffey there has said that the last line of the document we just looked at, there was a fear amongst staff that if you said anything about Gaytree, things could happen to you. Do you know what he's referring to?
I wouldn't know because I didn't have much interaction with other G4s staff beside the people who were in visits.
Chair, I just have a couple more questions. I appreciate that it's getting late.
Thank you.
Final brief topic, changes since Panorama. You've said that there are two changes. One is that the DES compliance team, with regards to the Home Office, is much bigger. And the second, you said the changes that we've switched to Serco, so the centre is now run by Serco. You said that in your witness statement, paragraph 116, all these changes are for the better. Is Brook House being managed by Serco better than G4s?
To be honest, I can't comment on that because I don't have much interactions because since COVID hit and Serco changed, I was working from home. So I've just recently, I think last year, went back into the office, but I didn't have any interaction because I do all my interviews over the phone. But I know that desk team is managing them every move they make.
So why did you say when it switched to Serco, these things are changed for the better?
Because when I call, like for example, if I ask the Serco staff in sense of telephone interviews, can you produce the resident or bring them to the office so I can speak to them and give them the paperwork? In that way, they're efficient, they would do it.
More efficient than when it was run by G4s?
Yeah, I would believe so, yes.
Thank you, Ms Smith. I don't have any more questions. Chair, do you have any questions?
I don't have any questions for you, Ms Smith. Thank you very much.
Thank
I'm
you.
very sorry that we've kept you waiting today, and I
It's
appreciate
okay.
it's a longer day than you thought it was going to be, but I'm grateful for you coming to
Thank
give your
you.
evidence.
Thank
Thank you.
Chair will resume at 10 a.m. with Jules Williams.
Thank you very much, Ms Townsend. Thank you. See you tomorrow.